All right, good morning. We will start with the call of the docket.
2025 CD 265 in re of Thomas Michael Bowers.
All right,
Morning, Your Honor. I represent Ashley Mowell.
good morning. So this is a petition for appointment of a conservator for Thomas Michael Bowers, is that correct? All right. Do you wish to put on proof that anyone who's going to testify, let's have them raise their right hand and be placed under oath? Right, you may proceed.
Sorry. Your Honor, I have Alma Bowers, who is the mother of both Thomas Michael Bowers and Randall Nathan Bowers. May I put my proof on simultaneously for both?
Everybody shift over in front of that microphone. Since we have someone on Zoom, we need to be able to hear.
Ms. Bowers, could you state your name for the record, please?
Alma Bowers.
And you filed this petition to appoint conservators for your sons, Thomas and Randall, correct? Those were filed September 15th, 2025. To your knowledge, is everything in that petition true and correct?
Yes.
How old is Randall?
He is 55.
How old is Thomas?
53.
What kind of medical conditions does Randall suffer from?
He needs 24-hour care. He had a head injury at 17, and he's unable to talk, walk. He's in a wheelchair. We're in a hospital bed. We feed him through a tube in his stomach.
Oh, ma'am. Does Randall, can you tell me what conditions Randall suffers from? Or is Thomas? I'm sorry, Thomas.
He suffers from seizures. They're uncontrolled. He takes medication, but and we've tried different things like a vagal nerve stimulator, which didn't do anything. And we have done all sorts of medicines that really haven't done a whole lot for him. And he's had the front 50% of his brain divided in half to see if that would stop them. And only thing I can say about that is he could have up to 12 grand miles a day, and he stopped having that many in his, but he still has a lot per month. He's on a drug right now. They're trying him on to see if it, and of course he's 53, and he's been having them since he was little.
Do they, either of your sons have the ability to make decisions or live independently? And they both reside in a special needs home, correct? Yes. Who are their treating physicians, do you know?
Yes, Susan Osborne.
And that doctor completed a physician report, correct?
Yes.
And we would file that report with the court, correct?
Okay. I don't have the name, but she's the one that handles it.
Do either Randall or Thomas have any significant personal property? And they both receive Social Security benefits, correct?
That's correct.
And you are able to ensure their money is managed correctly?
Development Services does manage the money, but
And you coordinate for their needs through the special needs home, correct?
yes,
And you ensure all of that their needs are provided for, correct?
yes,
And is it your desire to be appointed a co-conservator for your sons Randall Bowers and Thomas Bowers?
yes, sir.
Is it your desire to have your have Francis Robertson and Horace Carlton, Randall and Thomas's aunt and uncle, appointed as co-conservators with you? Do you believe that this conservatorship is in Randall's best interest?
Yes, I do.
Do you believe this conservatorship is in Thomas's best interest?
Yes, I do.
Do you desire for a property management plan to be waived from your requirements from the property management plan?
What that means is, ma'am, the law says that if you have assets of a person that you're going to become their conservator, and let's say they have a bunch of money in the bank or they have real property, then you would have to file what's called a property management plan that would allow me to see that you have a plan to properly manage their assets. I'm understanding that both your boys only have Social Security benefits and they're in a assisted living or a supervised living, and that money, I assume, goes to pay for that?
Yes,
All right. So I'm going to waive any sort of requirements for a property management plan.
Do you desire for a bond to be waived?
You don't have to ask her that. I'm going to waive the bond for you anyway.
Thank you. And Your Honor, I have Ms. Frances Robertson.
Yes.
Can you please state your name for the record, please?
Francis Robertson.
And have you heard everything that Ms. Bowers testified to as true and correct to the best of your information and belief?
Yes,
What is your relationship to Randall and Thomas?
I'm their aunt.
And do you desire to be appointed as co-conservator?
Yes,
And do you believe this appointment would be in Thomas and Randall's best interest? Mr. Horace Carlton? Please.
Horace.
And have you heard everything Ms. Bowers testified true and correct to the best of your information and belief? And what is your relationship to Randall and Thomas? Desire to be appointed as co-conservator? And do you believe this appointment is in Thomas and Randall's best interest? Your Honor, I'd like to pass up
All
two
right.
orders, if I could, please.
I have signed both of your orders and granted your request for conservatorship.
Thank you, Your Honor.
Good luck to you.
Thank you.
2026 CB 216 in re of Corey Michael Steele.
Good.
Morning.
Would you raise your right hand and let's place you under oath? Good morning. Are you Corey Michael Skillman Vidlich? How do you pronounce the last part? Vidlich, all right. You have filed a petition for a name change, and I'm required by law to ask you certain questions. Are you asking to change your name to avoid criminal prosecution?
Sir.
You're asking to change your name to avoid your just debts or creditors?
Sir.
You're asking to change your name for any illegal or inappropriate purpose?
No, sir.
Then I think it's just, you want to just change and drop the Skillman part and go by Corey Michael Vidlich, is that correct?
Yes, sir.
And that's to match your Social Security Administration. All right. Then have you prepared an order that grants that name change?
Yes, sir.
We have the petition, and there should be an order that
Yes, sir.
you have prepared as well. I'm going to draw a line here on the last page of your order that for you to sign off on, just because of the fact that I need you to hand that to him, if you will, please. That way you can, we'll have proof that you were here that day and you were approving the order. I have signed your order and granted your name change request. You can get a copy of this a little later in the day from the clerk's office.
Thank you.
2026
Yaros, come up, please. You will raise your right hand. Let's place you under oath. You have, are you Chance Curry? Is it Yaros?
Jaros.
Jaros, okay. Mr. Jaros, you have filed a petition for a name change, and I'm required, as you heard me, to ask you some questions. Are you asking to change your name to avoid criminal prosecution?
Yes, sir.
Are you asking to change your name to avoid your just debts or creditors?
Yes, sir.
Are you asking to change your name for any illegal or inappropriate purpose?
Yes, sir.
It's my understanding that you want to just change your name to simply Chance Curry, is that correct?
Chance Rose Curry.
Okay.
There should be an amended petition.
All right, an amended petition, I'm looking at the original ones.
I have a copy if needed.
No, I haven't. So what you're wanting to do is to change your name from Chance Curry Jaros to Chance Jaros Curry.
Yes, sir.
Have you prepared an order?
Yes, sir.
You will submit that to the bailiff. And again, I'm going to ask you to sign on the line I've drawn there just to show that you have approved the order. I've signed your order changing your name. You can get a copy of it a little later in the day from the clerk's office once they get the file back over there.
Thank you.
26 CB 112 Christopher Powell versus Ashley Mallett.
Ms. Collins is on Zoom. Ms. Carpenter, rather, is on Zoom.
Good morning, Your Honor.
We have a motion to withdraw.
Yes, Your Honor, we're going to strike that motion. I know we're set for hearing tomorrow. Does the court want my client present with the children in the morning?
I'm sorry.
I wanted to ask if the court wants my client present with the children in the morning. I think they're in Tennessee currently, the children with father.
I've been in Cheatham County for these, for the last several weeks. I'm going to look at this response that Ms. Roberts has filed, if I understand correctly.
Your Honor, if I could just kind of briefly, I filed this petition. Parties have two minor children together who lived here in Dixon County, went to school here in Dixon County. Mrs. Mao got evicted from her apartment at the Trails and packed up and left and moved out of state. She unenrolled the children in school with a few weeks left, a couple of weeks left in school, and left. We filed this petition. It was filed on April 14th. We had her served out of state on April 23rd. I set a matter for a hearing on May 18th before Judge Lockhart Mash. I believe the evening before the hearing, I received an email from Ms. Carpenter stating that she had been retained. I appeared before the court because, again, the children have left. My client went to visit with them and got the police called on him there. So when Mrs. Mal appeared before the court on the 18th of May, she was placed under oath and had to affirm on the record that she had in fact retained Ms. Carpenter and paid her in this matter. And based on that, the judge continued the hearing. And we had a hearing on May 29th where Ms. Carpenter and I just reached an agreement where they were just going to do equal time during the summer. And it was set tomorrow because the children, again, as your Honor's aware, Dixon County schools start on Monday. And so it is a matter that needs to go forward, and it's set tomorrow in front of Judge Lockhart Mash, and she's heard the other matters involved in that, so.
Well, wouldn't it be more appropriate for Judge Lockhart Mash to hear the motion to withdraw?
Well, yeah.
It's going to affect her hearing tomorrow.
Well, again, and that, my position is if Ms. Kerr has, if there's been some violation of the attorney contract by Ms. Mal. I certainly don't think you should have to be an indentured servant and represent a client who hasn't paid her, or is not cooperating, whichever it is. I know ethically she doesn't disclose that, but she said there's been a breach of the contract. So as a result, if she wants to withdraw, certainly she has every right to do that. But the hearing is set for tomorrow, and I implore the court not to give Ms. Mal any additional time to
Well,
file
it's not
count.
my hearing, it's in front of Judge Lockhart Mash.
And I have filed a motion for default set for tomorrow also.
Ms. Carpenter, I'm willing to grant your motion to withdraw because obviously, as Ms. Roberts said, if there had been a breach of your attorney-client relationship, then, you have the right to withdraw. But I am not in a position where I can continue a hearing in front of another judge anyway. So your client will need to be here tomorrow morning with the minor children for that hearing in front of Judge Lockhart Mash.
Your Honor, I'm striking the motion to withdraw. I just wanted to find out if the court wanted my client there in person. My understanding is the children are in Tennessee with father for parenting time currently. So I'm just asking if the court wants us in person tomorrow, which is fine.
Lockhart Mash does not allow appearance via Zoom.
All right, she needs to be here because Judge Lockhart Mash does not allow the Zoom appearance. So if you're striking your motion to withdraw, then the matter will remain set for tomorrow morning at 9 o'clock in front of Judge Suzanne Lockhart Mash. So,
Thank you, Your Honor.
thank you.
Thank you, Your Honor.
Judge, this is our motion to dismiss for failure to prosecute. I think the case.
How are you doing?
Not real good today. I think it's going to be Monday before I'm back at it, but
Anyone who's had surgery yesterday and shows up for court today has got to have a leather strap somewhere to chew on is all I can say. So.
I had one matter I didn't feel like could be reset.
All right, this is a motion to dismiss for failure to prosecute.
Yes.
You represent the respondent mother, Desiree Fluellen.
I do, and over the history of the case, Your Honor will note that Ms. Roberts was involved for some time, and I would hazard to guess, just like she hazarded to guess a few minutes ago, Mr. Phelan did not cooperate in communications with her. This motion to him by email. We've sent this motion to him by mail, I believe, and we're just asking that it be dismissed for failure to prosecute.
Matthew Phelan, case is dismissed for failure to prosecute.
Thanks, Judge.
I have filed a motion asking.
I think that would be appropriate. This is you and Ms. Duke.
Yes, and Ms. Duke and I are involved in it.
And I didn't know if we could get a reset date on that while we're standing here.
Fine, I can try to give you one. What case is it, the Jones case?
Jones,
It's a Humphreys County case I agreed to hear here, right?
yes.
And I just handed up to you an agreed order. Ms. Duke and I were able to resolve the real property issue, and we've signed an agreed order. I may have dropped that out. That's not, I think that's one of them up there. I was going to get you to sign, and I'm going to take it back to the conference.
And this is one that we did a really short reset on this one, just so that Mickey could get in touch
Can you hand this
with.
back, please?
So we don't have her here, so
If we could get 2 dates and then us just talk to her about it, I think we should be able to
she's
work.
down.
I could probably give you how long do you think it's going to take?
It'll basically just be a custodial determination.
I gave the children the home and gave
And
your
the children
parents
the home.
visitation
We
with the
resolved
home.
that, and she's buying the home, we're gonna refinance it. My client's moved out, so it's an establishment of a residential statute.
And Your Honor has heard quite a bit on this already. I think we probably won't go back behind the last order. I don't intend to. Ms. Roberts, I don't expect would, but so maybe over the last year, you'll hear testimony about that stuff.
I will repeat my question. How long do you think it's reasonably,
3 hours.
realistically?
3 hours, I think, is a fair.
All right, well, the reason I'm asking is, I don't have any open dates for the entire month of August, but I don't really have any open dates in the entire month of September. Now, I have August the 18th, which I am scheduled for Houston County Chancery Court. And I talked to my clerk yesterday, and originally I had told her to take that day off because it needed to be, I was trying to give something to Chancery, but I could probably give you the afternoon of the 18th.
I had 2 days in August that I'm available, the 18th and the 21st. I have no other dates.
Right.
Before everybody else
Now-
than that, so now I only have 1 day in August.
Where will we hear that?
Where you want to go? You want to go to my hometown of Erin?
That's fine.
You
with
want me to come back here, I can do it at 1:30.
I think here would be
I
great.
think
Oh, that's right, yeah.
Courthouse.
They're adding on to the courthouse there.
you have to kind of get to the elevator, EDA scenario, you have to go down steps to get to the elevator and then get, so I would rather,
All right.
do it somewhere where,
Well, I will let Ms. Brooks know that she has the morning, but that you have the afternoon, so.
What day of the week?
that's on a Tuesday.
Hopefully,
You want to
If-
double check with Mickey before we?
If she's not, then we'll circle back around. I have court with her this afternoon at 1 o'clock. She is, and so in juvenile, so I will check with her, and if that's not available, we'll get back with you.
Now, who has the Jones file?
Talk to Miss Abby. I told them that I wasn't going to bring it, because I will text Miss Abby and tell her I'm not coming to get it.
All right. Do we have anything else set tomorrow morning? There's nothing other than Jones, right?
Ms. Roberts and I have a few matters, but we're working through those, getting those reset.
those-
Yes.
All right. Is that all you have, Ms. Duke? Call the next case.
When Bruce Green versus Connie Lumpkin.
This is here on my motion to either compel Ms. Lumpkin to sign, to appear at the closing, or in the alternative, ask the court to allow me to enter an order divesting her of ownership of the property, investing it with Mr. Green for the sole purpose of concluding the closing on the sale of the properties. This is a case, Your Honor, wherein I filed previously involved. They purchased 2 vacant lots together. There has been significant amount of litigation in General Sessions Court, and then in Circuit Court on this matter. So we had to file a partition suit here. Your Honor granted the partition via default. We appeared before the court, got an order to sell the property by auction. Mr. Neil Trice effectuated the auction. It was sold, and we came before the court on March 23rd of 2026, and you approved the sale. The closing has been set. Ms. Lumpkin has failed to appear, has failed to file anything, has been served with this, is not present in the courtroom, has never appeared. And so I would request, Your Honor, I'll put on Mr. Green to verify what I have advised the court, and we would just ask for an order divesting the property with him for the sole purpose of him executing and closing the 2 contracts for sale on the property, and that all proceeds be deposited into the court after the cost of the sale, which you've already approved in the court order, and then have Ms. Lumpkin come before the court. The alternative process is for me to file a contempt petition, her to be jailed until she signs it. I do not want to do that. I think this is the most expeditious way to get this matter closed and the money paid into court.
All right, Mr. Green, raise your right hand. Let's place you under oath.
You are Mr. Bruce Green, is that correct? Yes, ma'am. Mr. Green, during the time that you and Mrs. Lumpkin had a relationship, y'all purchased 2 lots out on Furnace Hollow Road, is that correct? There has been a significant amount of litigation downstairs in General Sessions Court. It got appealed. It was in circuit. Mr. Potter represented her. We went through a number of things. We were able to resolve that, but y'all still ended up owing those 2 pieces of property together. Attempted to negotiate with her to get that taken care of, all failed, correct? We filed a partition suit, served her, and she failed to appear or file an answer, is that correct? And we took a default judgment and it came before the court to sell the properties by auction. We retained Neil Trice to do that, and he effectuated that and sold both pieces of property by auction. Is that correct? That's correct. We came before the court, presented the sales price, and the court approved the auction. Closing was set. You appeared to get everything and signed everything. You have a contract pursuant to this court order, 2 contracts that need to be closed out. And you understand what I'm asking the court, what we're asking the court is for you to be vested with the property for the sole purpose of you signing the deeds to the new purchasers. Then the funds will be deposited with the clerk and master, and we'll have to come back another day to decide how it's going to be divided. And you're asking the court to do that. And again, we've discussed the option of filing contempt and doing that. And again, this is the most expeditious way to fulfill your obligation under the contract that you signed.
All right, I will grant your request to authorize Mr. Green to solely be able to execute the deeds necessary to close on the sale of.
Thank you, Your Honor. I'll get the order over to you.
2019 CD 230, Michelle Santiago versus.
That is a show cause order. I've actually, it's amazing how a show cause order can get someone's attention.
Turn that microphone just, there you go.
It's amazing how a show cause order can get someone's attention, a motion for show cause, that is. I have been in touch with them and they are working on it. The lady is out of town this week, so if we could just pass that to another date. I don't know what dates it really does not matter what date.
Doesn't matter what judge, we can give you the next, how long away do you want it?
August the 26th.
The 26th will work just fine.
All right, call the Patton.
Good morning, Your Honor.
Good morning. Patton, it's my understanding that you have declared bankruptcy, that some notice has been given, is that correct?
That's correct, Your Honor.
And that basic of your bankruptcy, you've included the real property that I made a ruling on in this case?
Correct, Your Honor.
Based on the bankruptcy laws, and I'm foreclosed from doing anything regarding the real property that's included in your bankruptcy action.
Your Honor has already ruled that that real property is Miss Patton's.
Agree.
And he is holding a necessary insurance check that Your Honor has already said was awarded to her. This divorce has been completed for some time. Real property was awarded sometime. He's tried to backdoor it by filing a lien in the Register of Deeds office. This real property is fraudulently being placed into the bankruptcy court, and it should
That's
not
for the
be.
bankruptcy. I agree with everything you said. He has no basis to include this real property in the bankruptcy action. But a bankruptcy court is the sole judge, the sole area that allows for the for the determination of whether the asset that is alleged to do that. So Mr. Patton is treading in very thin ice with the bankruptcy court, because likely the bankruptcy court is going to find, as I have ruled, that he doesn't own an interest in that property. And as a result of that, he has attempted to defraud the bankruptcy court, in my opinion. And I think that the bankruptcy court will need to have an opportunity to determine that, because there's an automatic stay on any proceeding involving property that's alleged to have been included in a bankruptcy action until that bankruptcy court does that. But it doesn't stay this court from finding Mr. Patton in contempt of this court for failing to abide by this court's orders. You have not filed a motion for contempt, but I expect that's what you will do next.
That is what I will do next. We found out this notice was shoved into the door at my office in the middle of the night last night. So we've just found out about it this morning.
The notice of what?
The notice of bankruptcy. So that being said, I did want the court to know about the lien. He is still holding that check hostage. And he has filed some motion to have me disqualified as counsel because his girlfriend has some sort of relationship with Hidden Valley Properties, which our office represents, which is.
Let's hear that motion first.
Okay.
I'll allow him to argue that motion. You filed a motion to disqualify Reynolds, Potter, and Reagan in Vandervoort. You drafted this personally, did you, Mr. Patton?
Yes, I did, Your Honor.
Okay.
At this time, Your Honor, I am preserving my motion to disqualify under Tennessee Supreme Court Rule 8, RPC 1.7, 1.9, 1.10, based on overlapping representation and confidential information concerns.
I'm here. Anything you want to say?
I mean, I would like to preserve that for a future.
Reserve what?
The motion to just,
Now, we're going to go forward with the motion for disqualification
disqualify.
today. So you can argue it, and I'll rule on it. Tell me why you think that this relationship that you set forth with Mr. Vandervoort, being the attorney of record for a realist from some sort of Hidden Valley Lakes or whatever.
okay. Your Honor, regarding my motion to disqualify, there's a severe conflict of interest that breaches attorney-client confidentiality. Ms. Duke's firm represents Hidden Valley Lakes and its president. I volunteered there, and highly sensitive and private details regarding my active divorce were directly shared by this firm, or with this firm, by the president and Mr. Vandervoort. Opposing counsel has access to confidential information that can be obtained through that representation, and that creates prejudice against me with regard to the divorce matters. That completely undermined the integrity of these proceedings.
All right, I've considered your motion to disqualify, and I've reviewed your basis for that, and I find that there is no basis for disqualification of Reynolds, Potter, and Reagan, that the basis that you have set forth would have no effect upon this proceeding, nor would it have anything to do with Mr. Duke's representation of Mrs. Patton. Was there any other motion that needs to be dealt with today? Ms. Duke, I want you to draft an order that this court finds, as I have previously found, that this court has previously ordered Mr. Patton to execute the deed to this property as was ordered originally in the divorce decree, that he has been, the notice of lingua pendis. So that would be a situation where this court would have to deal with that, but I think the bankruptcy court's going to have to deal with that. But I will stand by the order that the court has made regarding the check that was from the insurance company, because I believe that was part of my earlier ruling, that he has 5 days to execute that check, and if he fails to do so, I will hold him in contempt. Mr. Patton, I think you're playing games with the legal system. I think you are attempting to try to divert or to avoid this court's rulings previously. I don't think you have any basis to include that real property in the bankruptcy action that you filed. You are getting some bad advice, and I'm telling you right now that that bad advice from whoever it's coming from, whether it's your girlfriend or some other person, whoever's giving you advice on how you can subvert and get around this court's rulings regarding this case is giving you bad advice. It's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders. But I'm not going to tolerate you playing games. And I don't think the bankruptcy court's going to do that either. And so you might get prepared, because I think the bankruptcy court, when Ms. Patton hires a lawyer and they proceed in the bankruptcy court, they're going to take a dim view of you attempting to use that process. Anyway, that's the order of the court. You may step aside. You may.
So, Your Honor, I had two other things that I'd like to discuss if possibly.
What are those?
So I would like to be on the record. I'd like to preserve that the deed was recorded before the written order was entered under Tennessee Rule of Procedure 58. A judgment is effective only when written and entered. And third, the deed acknowledgement is defective because I was never personally before a notary. And then, like I said, I asked that the property issues be continued. As far as the check, I have no knowledge of where that check is or where it's supposed to be. Ms. Duke told the court that it was at her office, and I agreed to go sign that check at the office. She later told me that it had been mailed to somebody or somewhere, and at that point in time, I have no knowledge or receipt of this check, Your Honor. So it's not a matter of trying to get around not signing it or avoiding it or anything like that. I have no knowledge of where this check is, and I've not been requested by Ms. Duke to come to her office and sign for this check.
Judge, we have confirmation and tracking that it was dropped off at Mr. Patton's home, and I can't control where the insurance company sends a check. I represented to the court that as they had told us, they were going to send it to my office. They did not. We've got tracking to show that it was sent to his house. He knows he has it.
Once again, Your Honor, I do not have the check, never received it. If it was mailed to the house, it's not at the house, so.
Ms. Duke, this court will order the insurance company to issue that check in your client's name only and to issue it directly to your office. And by order of this court, I'm directing the insurance company to issue the check solely to Mrs. Patton, and because she is the true owner of the property, and it's to be issued and mailed to your office, sua sponte. Secondly, your request regarding, or your objection regarding the deed execution is overruled and denied.
Understood, Your Honor.
And I will point out, the original order trumps everything.
This court ordered it from the bench, and it's just like any other order in this court. If it's not in, even though it may not have been a written order at that point, you were ordered to do certain things and you did them. So it doesn't matter if you signed a deed because I ordered you to do so, then later saying, well, that order hadn't been, the written order hadn't been entered, is an attempt to, again, subvert and get around what this court says. Why would you object to the order being, why do you even object? Tell me why that is.
Because I've filed a motion 60.02 to contest this whole process, Your Honor. So it's been under contest since I filed my motion 60.02. And then Your Honor ordered me to sign a quitclaim deed over on the 10th, or excuse me, the 15th.
I'm overruling your objection to the deed because of the fact that this court is of the opinion that you did so in compliance with the court's order. Your Rule 60 motion will have to be heard after the bankruptcy court deals with you.
Well, and it was in compliance with the final decree, so it even goes back that far.
There is nothing in the decree that states that I am to sign a quitclaim deed, Your Honor, and give up my rights to a $150,000 debt. It's attached to a $150,000 debt.
All right, I've made my rulings.
Understood.
Thank you, Judge. I'll submit an order.
Good morning, Ron.
Good morning.
Mr. Guerin stepped out.
I'm sorry.
I believe Mr. Guerin stepped out. It's his motions.
All right, well, we'll take a short recess and let him come back in, and once we do that, we'll deal you first, and then we're gonna go back to the Thomas case.
Thank you, Judge.
All right, we'll stand in short recess.
All rise, this court is back in session.
All right, we are ready then on the Claiborne versus Claiborne, Childress Claiborne. All right, we have her up here. It's unmuted. We're good. All right, this is a motion to alter or amend. Mr. Guerin, that's your motion. You may argue it.
That I filed on July 6th of this year. I'm not asking to relitigate the divorce, relitigate the contempt. I'm asking for very straightforward and narrow relief. I'm just asking the court to modify Ms. Childress's.
All right, the rule has been requested. Anyone who's going to be a witness needs to step outside of the courtroom and remain outside of the courtroom until you or yourself are called to testify. You're not to discuss the testimony of any other witness with anyone until you yourself have testified. Now you may proceed.
Thank you, Your Honor. And actually, as it relates to the witnesses, after speaking to Mr. Hawley, the witnesses may not be necessary. I subpoenaed 2 officers to testify that Mr. Claiborne received some of his property back from the police department. I don't think Mr. Hawley is going to dispute that. I believe Mr. Hawley was actually present for that. If we can get a stipulation of that, I can release the officers. The people he subpoenaed don't think that anything they'd have to say is relevant to my motion, so I don't think they're necessary either. Most of this is just legal and procedural issues. At the time that this court, back on October 31st, 2023, this court ordered by default divorce in favor of Mr. Claiborne and also granted the motion for contempt. And that's what I'm asking the court to alter amend the order as it relates to the contempt. Ms. First was ordered to pay the sum of $42,506.07 or serve 180 days in the Dixon County Sheriff's Office or Sheriff's Department. But at the October 31st hearing, you're from the bench, but the final order that Your Honor entered was, at least according to the certificate of service, wasn't sent out until June 4th of 2024. And then Your Honor entered it, I believe, on June 18th, which is well past the 20-day local rule for submitting the order. I've reviewed the file, and if I think I'm mistaken, but maybe I am, I did not see any other court dates between that October 31st, 2023 hearing date and the date that Your Honor entered the order. Based upon my review of the file, I didn't see any motions filed or any pleadings or anything occurring.
My recollection is there were no other court dates, that Mr. Hawley had submitted an order that I didn't agree with the wording of it, and I declined to sign that order and instructed him to redraft the order with what I thought was the appropriate language, and that took some time to do, but
Okay.
that's why it was not. There were no court hearings in between. It was just a matter of me reading the order, disapproving language that was used in the order, and then asking them to redraft it with the order that I thought was appropriate.
Okay. Well, that order does have a certificate of service on there, and those addresses and email address were not good contact info for Ms. Childress, so she never received the order, despite a few times after the hearing date she called up here, called the clerk's office to get a copy of the order, and she was told every time that you just have to wait on the order to be filed. She only learned of the order after being served with the capias some almost 2 years later. We're now about 3 years out from where the order was filed. And all these items that are listed in the order for her to return, some of the stuff Mr. Claiborne has been reunited with. There's really nothing in the record to suggest that Ms. Childress still has these items. There's nothing to suggest that she has this $42,000. I understand it's a civil contempt, but she has to have the ability to purge herself of this, and there's nothing to show that 3 years later that she currently has the ability to purge herself of this contempt. So basically what we're looking at now is basically a debtor's prison. She doesn't have the ability to purge herself, which there's nothing to show that 3 years later she now does. It's become punitive. And because of that, Your Honor, I would ask that the court alter its order or just enter a new order to release her to show that she's, she's been in jail, 4 months now? The appropriate remedy for Ms. Childress would be to release her from custody. So I'd ask that you grant our motion, modify her sentence to 10 days, and to release her time served from the Dixon County Jail.
Dolly, you wish to make an opening statement?
So I remember that we did have some court dates after that October date, Judge. I have put together, and I've given a copy of it to Mr. Guerin. This really is nothing.
You may be correct. This has been, that order was from a hearing in 2024. And as a result, I'm not sure that my memory of it would be as clear.
I've shared this with Mr. Guerin. We talked yesterday, and then I gave him a full copy of my timeline today that's got everything attached to it. I tried to streamline this because this file is rather voluminous and different orders and things flying around. But this is all the orders, the motions, the things that I felt like were important to and germane to our issues here today. You look at the timeline, there was a February 15th, 2024 court hearing, and what all led up to that a little bit. And then there's also a June the 4th hearing on the motion to approve the order. And we did have those other 2 court dates. I had lodged an order with the court. And again, the court had some issues with the order, wanted some amendments. And we had that February 15th hearing, which I sent notice to Ms. Childress at the 2 physical addresses and her email that I had. And we had that hearing, and the court instructed me on what to do and then there was another change on the 4th of June at our hearing there. And then I submitted an order that the court signed on June 18th. So this court took special care with this order. The first order I sent in, I did it like I do the civil contempts and whatnot, jailed indefinitely. And the court said, no, you didn't want that. You wanted a provision in for her to have 6 months of incarceration and to be let out after that. So she was not jailed indefinitely. And there's some other things in there too that this court did that, again, taking careful consideration with the order that you did. Our position today, Judge, is really one of a few things. One, I've filed a response in opposition. If we're going to oppose this, obviously, I think the court, I can get into the argument on that if the court wants, but I think the court took great care with this order. I don't think there's anything that's inappropriate with this order. If the court will remember, it was a fairly egregious situation where she had gotten a domestic assault on Mr. Claiborne, got control of the house, and basically ransacked the house. And the court heard hours of testimony about defecation in drawers of Mr. Claiborne's clothes, urination on the furniture and the beds and things of that nature. There was a lot going on at that time. And Judge, basically, we are asking that, number one, if we're going to go forward with the motion to alter or amend, that be denied. I think the court did what the court was supposed to do with that. Number two, let her out of jail with some stipulations. We're fine with that. If she's here today, basically wanting to get out of jail, that's what this motion is about. What we're about today, Mr. Claiborne just wants what's due, what his justice is out of this order that the court did. Either his stuff back or the money paid, and we've already beat that horse all the way around the track, and there's an order down for that. But we say she's got some time left on her 6 months. Let's stay that, or however the court wants to do it. This is contempt, and the court has the absolute reins, in your hand to do what you want to do here. You're driving this bus. Let her out of jail. Let's reset this maybe to the 1st of December. Give her a little bit of time to either make some payments, get this stuff back. Let her know that this is a serious matter. I don't know if she understood it was this serious, but let her know it is a serious matter. And let's come back in December and see what she's done, and it's up to the court then to do what the court wants to do, to see what her conduct was during this period of time. Not getting any satisfaction here seeing her in jail. Mr. Claiborne wants the return of the property or his money back. And at that time, there was a present sensibility for her to be able to return this property. The court found that. It's in my response. And I'll be glad to go over the response and argue this in detail if we need to. But at this time, we're fine with letting her out. But put a few stipulations on it that we've got a reset date. I may want to file some interrogatories about her. We think maybe she's gotten a settlement, some things like that. We want some sworn answers about that, and either continue this motion to alter it until then, or do whatever the court wants to do. But we're fine with that as well. That's, I think, probably the preferred remedy for Mr. Claiborne, to be honest with you. So one of those two is what we're requesting. And again, I'm a little in the dark here as to what we're doing. If we're arguing only the legalities of this, I'd like some more time. If we're calling witnesses, obviously that's up to Mr. Garrett, it's his motion. But if we're calling witnesses, I may call some witnesses, especially Mr. Claiborne, to contradict some of the things. But by and large, if we're going to argue this legally, I'd like to have opportunity basically to argue it legally. But those are, as far as my opening statement goes, that's what it is. Thank you,
Well,
Judge.
this court considers this situation to be similar, if not exactly like a father who has not paid his child support and has a large arrearage of child support under a court order and then fails to comply with that, then there is a remedy that's given to the court, and that remedy is for civil contempt. The first order that Mr. Hawley, I think, drafted, if my memory serves me, included language that she would either return all of these items or pay him the amount, or she would be incarcerated indefinitely. And I think that was the part that I objected to, because under the law, I can only punish someone by giving them jail for 6 months at a time for civil contempt, but I can do that twice a year, as has been pointed out in the child custody cases. But even in the most egregious child custody cases, what happens is you give someone an opportunity to see what it's like to be in jail so that you can hopefully motivate them to come in compliance with the court order. Civil contempt versus criminal contempt. Mr. Guerin makes the argument that this case has transitioned from civil contempt to punitive, and therefore criminal contempt, and that's his argument, that she's could only be punished by 10 days in jail for criminal contempt. But this court disagrees with that, because under the circumstances, this court heard this case over many, many different court dates, and there was an egregious set of facts in this case. There was a short-term marriage, and sometime shortly after they had married, Mrs. Claiborne got an order of protection against Mr. Claiborne and dispossessed him of his own house, the house that he owned prior to their marriage. The evidence at the trial was that the house, when he left it, had numerous items of personal property that belonged to him and his late wife, and that during the course of the time that he was out of the house, that Mrs. Claiborne had visitors, a number of visitors and parties and things at the house, that the next door neighbor testified that, and took pictures of parties at the hot tub behind the house and different things that were going on like that. So when I ordered her to vacate the house, because it was his home, on a temporary hearing, then she vacated the house. But the testimony was that numerous items, a great number of items were removed or damaged, and that, in fact, what was more convincing to the court than some other things was the fact that there was testimony that the drawers of the dresser in the bedroom had been removed and feces had been smeared on the bottom of those drawers. That indicated to me a malfeasance on the part of Mrs. Claiborne or someone acting on her behalf that justified a finding that she should be required to make Mr. Claiborne whole. The fact is, in most divorce cases of very short marriage, the idea of the court is to hold that parties would be restored to the same position they were in prior to the marriage. Mr. Claiborne owned that house before. He owned all of those properties beforehand, and all of those personal properties beforehand, and that they were missing at the time. We had an extensive hearing where we went through all of the list of items that Mr. Claiborne had that he testified were missing, and the court found that it was justified to hold that she was responsible for their removal while she had possession. It's kind of like what we studied in law school. You know, when you were in possession of someone else's property, you're kind of in bailment of it, and when it goes missing with her, situation that, obviously, she had a number of people there in the house. Some of those were, not particularly reputable characters. And in fact, I think one of her friends testified against her at the final hearing in this case anyway. So I found that she was responsible for the loss of all of those items of property and that Mr. Claiborne was entitled to the return of those items and that she had them or she had destroyed them. And if she had them, she could return them. If she destroyed them, she was liable for the value. I had a hearing. I made a finding as to the evaluation of that property, and I ruled that she was responsible for it and that she should make those payments. And she failed to do that, and that's where the order for contempt came in, and I found that she was in willful and deliberate contempt because those items had been removed or damaged. She knew, either where they were or she was responsible for them. And as a result of that, I think it was just that I entered that order. That is no different than if a father or a husband had dissipated assets. Let's say instead of personal property in the home, there was a $50,000 checking account, and one of the spouses had surreptitiously removed that $50,000 checking account. They would be held responsible for that money. And that's the same thing I did in this case. As a result of that, I'm of the opinion that the motion to alter that Mr. Guerin has filed, and I've considered it, and his argument that it should be converted to a criminal contempt and 10 days in jail is denied because I think that I was correct in my ruling initially. But as I have pointed out, even in a case where a father owes substantial amounts of child support, after a period of incarceration, it is usual for the court to give that person an opportunity to be released by suspending the balance of the sentence and then allowing them to be back out on the street, so to speak, trying to find a job and trying to find a way to pay this. This court is of the opinion I was correct in the amount that I set or the items that would be returned. If items have been returned to Mr. Claiborne that since the entry of that order, then those items, the valuation was set forth in the order that was found, and those items, the value of those items would be deducted from the amount that she owes, just like a payment had been made on child support. The remaining balance would be her responsibility. And therefore, I find that the appropriate and equitable matter in this matter is not to amend or alter the order, but rather to suspend the balance of her sentence for civil contempt at this time, allow her to be released with the condition that we set a review. I think I'm back here in September and then again in January. We'll set it for review in January to determine whether or not she has made any progress. And I'll be honest with you, if she's making payments towards that satisfaction of that debt, then just like a father in a child support case, I will give her an opportunity to continue doing that. The January the 5th, how about let's make it January the 26th. That'll give her a full period of time. January 26th, we'll set a review date on this case. In the meantime, she is released with the understanding she is going to make progress towards satisfaction of the debt, and then we'll take a look at it at that point in time. Yes.
One of the issues was her not receiving notice. That was in the motion.
One of the issues was what?
Her not receiving notice of some of this stuff at the end, and I did what I was supposed to do. I did the certificate of service to her 2 physical addresses I had and her email. Can we put in the order that she's required to let the clerk know what her current address would be?
It is the
for mailing
responsibility of all pro se litigants, or if you have an attorney, that she must keep in touch with the clerk's office to give us a valid address. So, Mr. Guerin, I will put in the order that your client must provide Mr. Holly with her current address. That's fine as long as the fact is that she's being released, but on a specific review date, then I want to know where she's living, because if she doesn't comply with the court's order, if she just vamooses, then we're gonna have to issue a warrant for her. And I'm not gonna arrest you. I'm gonna send it for her.
Yes, sir.
So I
just
think
need
the
address.
best thing to do is to just require that she provide you with her current mailing address. Now, when she has that address, the order will provide that Mr. Claiborne is to have no contact with her. In other words, if he doesn't contact her by mail, by phone, or any other means, and she should not contact him. Let's just separate them. They don't need to be together, and I'm making that a ruling. But I do think her address being a part of the court record when she's released is no different than, again, I'm treating this like a father who's been behind in child support, so.
I just want to make sure I'm doing the right thing and sending it to the right spot. If Mr. Guerin wants to be responsible, I'll be more than happy to send it to him. And just to announce to the court, I may want to file some brief interrogatories about, basically her ability to pay. We think she may have a judgment. There's some other things. So I may want to ask a couple of questions about receipt of the monies for that judgment. And if we've got items that he's received, I will get with him. I will get with Mr. Guerin. We will attempt to work that out. If we can't, can we reserve that for the review date in January?
That's fine. I think it was Exhibit A that was the listing of the items that you had.
And it's in my timeline. I put that June 18th order in that timeline, and I gave a copy of it to Mr. Guerin today, so if he'll look, you should have Exhibit A in there for his records. Yes. There's a June 18th order in there, and it should have that Exhibit A
I wanted Mr.
attached.
Guerin to be aware of the total amount of the judgment that was entered against us, so that's why. I'm sorry, how much? 42,000 and some odd dollars, all right. And whatever the value is of the property and all of that valuation is set forth on that Exhibit A, so deduct from that balance what is owed and
Yes, sir.
what the value of that property would be. And we'll go from there.
That's well understood, Judge. We'll do that. And then again, if there's any dispute, we can, if it pleases the court, I can put that to order. We'll just reset that for January.
All right,
Can we reserve attorney's fees and have that at our review date as well?
certainly. We need to have an order signed that would allow it and set it for review. You all can draft even just a simple order that she's to be discharged subject to a review and then supplement that with a more complete order. Then that would be the best way to handle it. So if you can do it today, I'll sign it today. I saw Lieutenant Martin or Captain Martin or whatever he is, one of your witnesses. You want to bring him in here, we'll tell him what I'm doing, so in case that makes a difference for the jail. I have completely destroyed your files. I don't even know how I did that. All right. Excuse me for blowing my nose. I took it apart, probably. I am ruling that we're going to let Miss Claiborne, I'm going to discharge her from jail today and subject to a review, and there will be an order. It'll take a little bit for them to get a typewritten order, but she's going to be discharged on the civil contempt and be brought back in January for me to review what she's done. So I just want to let you all know so that even if she needs to get out of there, then y'all can let her out by my order to you today, because even if the written order takes a little bit.
Yes, sir.
All right. Y'all are free to go, by the way. You want to let your other witnesses know they're discharged? All right. That'll conclude this hearing.
Thank you, sir.
Mr. Dabbs' motion for default is granted. He'll be awarded an absolute divorce on the grounds of inappropriate marital conduct. Personal property will be divided as said. And then you said you wanted to sell the
trailer. It's just the trailer, Your Honor.
all right. Then that will be your motion to sell that personal property will be granted, and his proposed parenting plan will be adopted. So you'll prepare that. In the absence of any proof, though, I think I'm required to set it according to minimum wage R2, and I think that's what we would do. Set it at minimum wage. All right. Thank you.
I pushed real hard. I'm a
So-
button pusher.
Well, you got it to light up, but it's not picking up any
Oh,
sound. So.
sorry. What is lit up? I don't know how to adjust the volume, so
All right.
And-
All those who are going to testify, raise your right hand. Let's place you under oath.
yes. Now you understand you have to speak loudly because of the
Okay.
courtroom, okay? Please state your full name for the court.
Kim Michelle White.
You came to my office more than 60 days ago and filed a complaint for divorce. Is that correct?
Correct.
Is the information stated in that divorce complaint still correct today?
Correct.
You're
Yes.
not living with your husband as husband and wife,
correct.
and you're still asking for a divorce.
Yes.
You don't believe there's any chance of you reconciling.
Absolutely not.
Okay, you allege that he was guilty of inappropriate marital conduct. Is that,
Correct.
was he physically abusive of you?
Yes.
And did he assault you?
Yes.
Okay, so are you asking the court to award you divorce based on inappropriate marital conduct?
Yes.
You've been married 5 years, is that correct?
4.
4 years, going on 5. This
Yeah.
is the 5th year. And you owned real property before the marriage, is that correct?
Correct.
And you have paid that mortgage,
Correct.
and he was never added to it.
No.
So you're asking that you be responsible and receive sole ownership of the real property. Is that correct?
Correct.
Now, you, at my assistance, you have prepared a division of marital assets. You said there's a few items at the home that belong to him.
Correct.
That being an entertainment center with stereo equipment, desks, 2 monitors, office chair, and other miscellaneous items. Miscellaneous office items, clothes, shoes, radio tower, 4 tires, and wheels. Is that correct?
Correct.
And you are asking the court to award him those items.
Correct.
And you're asking that he have 30 days to remove them from the residence. Is that correct?
Yes, please.
And after that time, he will have abandoned them, correct?
Correct.
Okay. Now, is there any debt that's in both names?
There is one loan that he might be on for renovations,
But it
but
was
I'm
for-
paying it.
And so you would be solely responsible for any debts with marital residence, correct?
Absolutely.
Okay. And you own a 24 Ford Maverick, correct?
Correct.
And he owns a 24 Toyota Prius. Is that correct?
Correct.
You're asking each of you, take those items and be responsible for any debt that's on those.
Correct.
Okay. You're asking to be restored to your maiden name of Kim Michelle Knapp. Is that correct?
Correct.
You're asking that he be responsible for the debts in his name and you responsible for the debts in your name.
Correct.
And as far as retirement account, you have a retirement account, correct? But you've only been married 4 years. Is that correct?
Right.
So you're asking that you be responsible, that you receive ownership of that account. Is that correct?
Correct.
All right, you want to put on your other witnesses?
I do. Please state your name for the court.
Diane Hamilton,
How long have you known Miss White?
58 years.
Do you know her to be a truthful person?
Yes,
You know what she said today to be true and correct.
yes.
Ma'am, please state your name for the court.
Sherry Beeman,
And how long have you known Miss White?
60 years.
And do you know her to be a truthful person?
Yes,
Do you know what she said today to be true and correct?
absolutely.
Motion for default will be granted. We have sound.
Your sound. Oh, goodness, we did too.
Thank you.
Good morning, Your Honor.
Good morning.
Tia Bailiff on behalf of Mr. Upchurch. We're here on my motion for default judgment and for attorney's fees. Your Honor, we filed a complaint on April 27th of 2026. The complaint was served April 28th of 2026. Mr. Jacobson filed his notice of appearance on April 29th of 2026. On June 2nd of 2026, we filed our motion for default, and no requests for relief from timeframes for the rules of procedure were requested at any point prior to us filing for a motion for default or even prior to today's hearing. The appropriate time to have done that would have been prior to the motion for default being filed on June 2nd. But honestly, Your Honor, any time from June 2nd up until our requested time to extend, but it didn't happen. So pursuant to Tennessee Rule of Civil Procedure 12.01, answer is required to be provided within 30 days of the petition being served. In accordance with Pash Industries LLC versus Wallace Hardware Company, 2003 Tennessee App Lexus 802, it says a defendant shall serve an answer within 30 days after the service of the summons and complaint on him. It further states that the belated filing of an answer is not an adequate response to a motion for default. There must be some application to the court for relief from the failure to timely file an answer. In Pash Industry, in that particular case, the defendant was served on September 9th of 2002, and a motion for default was filed 11/1 of 2002. The answer was then filed 18 days prior to the hearing on the motion for default, and the default judgment was granted. The motion to set aside the default was denied on the basis that it is not curative, that the belated filing of an answer, and certainly that it was willful conduct that led to the untimely filing. In Harris Building Group Incorporated versus Tennessee Electric Incorporated, 2019 Tennessee App Lexus 293, the court addresses specifically what willful conduct is in failing to file a timely answer. It says willful conduct includes deliberate choices and conduct that is flagrant and unexplained. And Your Honor, if it would help, I did print these court so that you could follow along if you needed to. On Harris Building Group, on page 4 of that opinion, it talks about the deliberate choices and conduct being flagrant and unexplained. And it says, where a record lacks an explanation for a flagrant violation of the procedural rules, the conduct is willful and therefore ineligible for relief on grounds of excusable neglect. The conduct was willful when the defendant failed to file a timely response to the petition, despite being fully aware of the court proceedings. In that case, the timeline is much like the one here. It was served on July 5th. The motion for default was filed August 11th. And then the answer was not filed until months later. APAC ATL Inc. versus Morton is much of the same, Your Honor. The contractor failed to answer until the day before the scheduled hearing on the motion for default, in a hearing almost 4 months of the service of the complaint. That is directly what happened here today. An answer was filed at the 11th hour on Friday, July 24th of 2026, almost well over 3 months after the service of the complaint. And in this particular case, there was no extension request filed. There was nothing before the court that indicated that there was anything but sitting on their rights. The Court of Appeals is quite clear also in Myers versus Myers 2010 10 App Lexus 765 that were this court to grant the default judgment for failing to obey the rules of the Tennessee Rules of Civil Procedure and failing to file an extension, which the case law yields they should, and actually yields they must have prior to filing this answer, that the Court of Appeals would absolutely uphold any decision for a default judgment that this court would enter. And in our motion, we specified and redirected to the complaint exactly what was that we were seeking. Thank you, Your Honor.
Good morning, Your Honor. John Jacobson. I'm sure Your Honor's not seen the declaration that filed this morning on my behalf. I've brought a copy for counsel and for the court.
I'm sure if it was filed this morning, I have not.
Yes, sir.
served it. It is in the file, so I'll look at the one in the file.
Your Honor, and most of those facts are undisputed. The nuance here is this was filed in April, I think 27th. The plaintiff sought ex parte TROs, I believe the day the complaint was filed and the following day. I'm not certain because there were no orders entered on that, but I was advised by plaintiff's counsel that the court denied those. I entered an appearance, sent an email asking that the plaintiff preserve documents, and the whole, I think the catalyst for this lawsuit, this docuseries that my client posted on social media outlets, started the last week of April, and as I understand it, the last of 4 episodes was published on sometime in late June. Counsel did file a motion to compel. I did, in fact, though, email her in mid about the schedule. And there's another client in a case that is not related, but it's another former employee of plaintiff that she had asked me in an earlier email if I represented him and was authorized to accept service for him, which I had informed her I was. I never received anything on that either. I emailed her in June and to ask about the schedule on filing and answering the case, and whether or not she had filed this other case, had tried to serve anything on me. I received no response. I called once in early July, received no response, and sent an email Friday and received no response. So it wasn't as if we ignored this, Judge. And while this started out with a bang, with this request for extraordinary relief, nothing has happened in the case since, Your Honor. Plaintiff has not sought to take any discovery, served any written discovery. And frankly, when the motion for default was filed and the hearing for the motion was set on the 27th, I assumed incorrectly that if we filed our answer by then, that we would resolve this motion for default. And that's the here, Judge, but there's no prejudice. They've nothing to push this case in the interim, and we would ask, and the cases are both the Tennessee Supreme Court of Appeals, Your Honor, as you know, in all 3 sections have routinely held that defaults are generally disfavored in Tennessee. Cases should be heard on the merits. There is a case, a Tennessee Supreme Court case, Your Honor. The name was Youree, Youree, in which a default judgment was entered in Davidson County. The middle section set the default aside. The Supreme Court affirmed because in that case, the cause of action was a piercing the corporate veil, and the court found that the allegations in the complaint didn't even support that cause of action. There are at least 3 causes of action in this complaint, Your Honor, that we submit have the same problems: fraud, intentional interference with business relations, and unjust enrichment, none of those make sense in this context. And so for those reasons, Your Honor, we ask the court deny the motion. We're happy to enter a scheduling order, Your Honor, whatever we need to do to move the case along, but do not think default judgment's appropriate. Thank you, Your Honor.
Bailiff, we have a response.
Yes, Your Honor. I think it's indicative that the declaration was filed the day of the hearing. And for the first time, I saw it while sitting in front of you. That is part and parcel of what's happened in this suit. The catalyst for a lawsuit is not a docuseries. It's a breach of a fiduciary duty. It's intentional infliction of emotional distress, unjust enrichment, and several other claims. To say that nothing's happened and discovery has not been filed, it would be because the defendant failed to participate in the suit appropriately. It would be absolute malpractice and a waste of my client's money to shoot in the dark on a 44-page complaint to seek discovery for every individual thing if they were simply going to admit to it. So that argument doesn't really hold water.
Well, let me ask this question. Excuse me for interrupting.
Yes, sir.
Mr. Jacobson, in his declaration, indicates that he has been in contact with you regarding this case and has notified you that he was involved. According to said, he emailed you, or rather, you emailed him on May the 11th. He had noticed that he had entered a notice of appearance on April 29th, and then it says basically that there was no action taken between May 12th and June 2nd. And so I'm asking, were you aware Mr. Jacobson was involved in the case? And do you have contact with him?
Your Honor, absolutely. But the way that was represented was not accurate. To be clear, I was aware Mr. Jacobson existed because the day after his client was served, he filed a notice of appearance in your court. So he's been on the case since April 29th and not filed an answer. The way that he represented it would indicate that potentially we had some kind of meaningful communication related to this case, which we did not. The email that he's discussing is related to someone who has not yet been sued. We have not decided whether we are going to sue. That was a former employee that when I tried to speak to them to relate some of the concerns that we had, they said that they were lawyered up by Mr. Jacobson. So before we took any action, I wanted to ensure whether that person was lawyered up. He did not communicate with me related to Mr. Shepard in a way that I was able to receive at the time. I'm not certain if this court is aware, but I recently underwent emergency brain surgery. Be happy to show you. I have been out of the office as a result of convalescing for brain surgery. In fact, this is my first court appearance back, Your Honor, and I'm happy to see you. I'm happy to be here.
I'm happy you're here.
So I did not receive any communications from Mr. Jacobson, but I was very clear in my motion for default judgment. And in that clarity, I specified that a late filed answer would not do the trick here, that according to the laws of the state of Tennessee and the Tennessee Rules of Civil Procedure, a late filed answer just would not cut it. The rules say shall file. And then the case law says if for some reason you cannot comply with Rule 12.01, it's very simple. All you do is you file a request with this court, and this court has discretion to grant an extension of time. Not me, Your Honor. I don't have that authority. This court does. So my motion for default was clear in what the intentions were, which was don't sit on your rights. Let's think forward. And honestly, I would never do discovery that rapidly on a case when it's a complaint. I just don't think that would be prudent for my client. I think that would not be a good steward of his finances.
Well, this is a situation where obviously it's a conflict of the plaintiff's position and the defendant's position, but it boils down to whether or not the court should grant a default judgment, even though an answer has been filed, albeit late. And certainly Ms. Bailiff has made a compelling argument that the case law is clear that appellate courts will uphold this court in ruling that a default judgment should be entered. Difference that I see in this case is that Mr. Jacobson has made known that he was involved in the case, and apparently from his declaration alone indicates that he was attempting to have contact with Ms. Bailiff. Ms. Bailiff obviously had reasons to be out of the office, but that he, in his declaration, states that between May 12th and June 2nd, the plaintiff took no action, that the motion was filed on June the 2nd. On June the 23rd, Mr. Jacobson says he emailed the plaintiff's counsel advising her he had not seen anything from her regarding Trevor Broad and suggesting a schedule for filing the defendant's answer to the complaint, but there was no response because she was out of the office, obviously. It is this court's opinion, and I think that case law is clear, as Mr. Jacobson said, that cases should be decided on their merit rather than on technical issues, and default judgments are not favored, based solely upon the fact that Mr. Jacobson was involved in the case and made known his appearance, and apparently there was some miscommunication, misunderstanding on his part regarding of his filing an answer because of his contact with Ms. Bailiff, and Ms. Bailiff had been out of the office. That I find that the late filed answer should be admitted and the motion for default should be denied. Ms. Bailiff will be entitled to file a request for attorney's fees for her appearance in the preparation of the motion for default and for her appearance today. Ms. Bailiff, if you'll file that, I will approve.
Thank you, Your Honor.
Your Honor, would you like me to draw an order?
Yes. If he's in jail, let's see if we can get him in here. Are they going to bring him in, or is he going to come in on Zoom? Just go ahead and bring him up, and then when we get him here, we'll take it up. Just let us know when he's here. We're going to skip over the Tammy Doris versus James Doris because Mr. Doris is in jail. As soon as we can get him up here, we'll come back to it. Go ahead and take up the next case.
Good morning, Your Honor. This is a request for exception to claims in regards to the Allison estate. There are 4 of those. There's one for $130, one for $255, one for $27,407, one for $7,601.
Anyone here to represent Centennial Medical Center to prosecute their claim? No one here to prosecute. Your exceptions are granted. So,
have a good day, sir.
well, if you'll raise your right hand, let's place you under oath.
Yes, ma'am.
You have filed a petition to change your name. I need to ask you a few questions under oath. Are you asking to change your name to avoid criminal prosecution?
No, sir.
Are you asking to change your name to avoid your just debts or creditors?
No, sir.
And it states here that you want to change your name to Tristan Douglas Hanson. Is that correct?
Yes, Your Honor.
All right. You have an order prepared that I think you submitted, and looks like you signed off on it. So I will approve your name change. You'll need to get a copy of this a little later in the day once it's been transmitted to the clerk. Okay.
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
Both of you raise your right hand. Let's place your under oath. You are Corey Wyatt Goins.
Yes, sir.
Mr. Goins, you filed a complaint for divorce using a form the state provides online to individuals wishing to represent themselves. Excuse me. That form contains certain statistical information. Is all of that information true and correct?
Yes, sir.
Pardon me. You've also filed a marital dissolution agreement that purports to bear your signature and that of your spouse. Is that your signature?
Yes, sir.
Do you believe that agreement fairly and equitably divides all of your property and distributes all of your debts?
Yes, sir.
Is there anything between you and Ms. Goins that's not addressed in that?
No, sir.
You are Jennifer Goins, is that correct?
Yes, sir.
Ms. Goins, is that your signature on the marital dissolution agreement?
That is correct, sir.
And do you believe that agreement fairly and equitably divides all your property and distributes all your debts?
Yes, sir.
Anything between you and Mr. Goins that's not addressed?
No, sir. I do believe my name changes in there as well.
Your name changes, I think, a part of that agreement. You need to prepare a final decree of divorce. Have you done that?
I think so. I have these 2. I think it's this one that I need to fill out, but they said to wait to fill that out until today.
Is that you have the form, but you've not filled it out? Is that correct?
Yes, sir. The final decree with marital dissolution agreement form 6.
Right. You need to fill that out, and then you can file it with the clerk downstairs, the Chancery Court clerk.
Okay.
And both of you need to sign off on it, make sure it's completely filled out, and then just leave it with them, and I'll sign it later today.
Yes, sir.
All right. Thank you.
Your Honor, I'm not currently an attorney of record in this matter, but I am going to be representing Ms. Tackett moving forward. We just worked that out this morning.
Well, this is a motion for default judgment. Ms. Tackett was representing herself pro se when she asked for that.
Yes,
So
Your Honor.
how do you want to proceed on this?
We're ready to move forward.
Is this Mr. Tackett?
No, I am Jimmy Dustin Jones's father, and I'm here to let the court know that he is incarcerated today and he gets out Sunday. If we could move this to next week or week after to give him time to get over here.
Your Honor.
Come up. Sir, come up just so I can make sure I understand you. Stand at the podium. It's my understanding you're the father of the defendant.
Yes.
All right. And you've said that Mr. Jones is in fact incarcerated.
Yes.
Where?
In Robertson County.
Okay. And why is he incarcerated there?
Failure to appear and violation of probation.
And you're asking on his behalf to move it to another day to allow him to have time to hire an attorney?
Yes, sir.
When is he scheduled to be in court?
Over there. Oh, he's already went through, and they give him so much time, and he got on the program there where he gets day for day, and so he gets out. His release date is August the 2nd, and he's done over there. All his fines been paid and everything.
Your
All
Honor,
right, you can have a seat, sir.
Yes,
Thank you.
I think that you can see in the file that the defendant was served a year ago nearly. At the time that he was served, he was not incarcerated. So from July until March, he was not incarcerated, did not file an answer, did not participate in this divorce. So we would ask that he be found in default today and this matter be allowed to continue forward. For the record, they have no children and no property. This is just a divorce.
Well, that's my review of the court file indicates that there are no minor children and it does not allege that there's any marital property to divide. So it's basically just granting a divorce or not granting a divorce. The court's review of the file indicates that he was in fact served. This case has been pending over a year and that he was served, and therefore I will allow you to proceed on your motion for default. If Mr. Jones has some objection to what the court does in this case, then he has the right under the rules to file a motion within the specified period of time. But we're going to go forward with it today.
Thank you, Your Honor.
All those who are going to testify, raise your right hand and place yourself under oath.
Yes. Can you tell the court your name?
Deborah Tackett.
And you filed a complaint for divorce on your own, is that right?
Yes.
And since then, your soon-to-be ex-husband has not participated in that or called you or tried to settle anything with you.
No.
And as of today, everything in that complaint is still true.
Yes.
You're still separated and you're asking for a divorce.
Yes.
And isn't it true that you have had an order of protection to protect you from him in the past?
Yes.
And so you're asking today that you be granted a divorce based on his inappropriate marital conduct.
Yes.
All right, that's all I would have, Your Honor.
And there is, I believe she's testified, there's no property in.
Sorry. Yep, let me ask you that. Y'all don't have any home that you own together?
No.
You don't have any minor children?
No.
You don't have any joint debt?
No.
And so you're asking that everything that you have in your possession is yours, anything he has in his possession is his, any debt in your name is yours, any debt in his name is his.
Yes.
And you're asking that you have separate car insurance, health insurance, and cell phone.
Yes.
All right.
Thank you. You can step over to the side. Can you tell the court your name, please?
Hannah Jones.
And Hannah, how do you know Miss Tackett?
It's my mom.
And do you know her to be a truthful person?
Yes, ma'am.
And you've heard everything she said today?
Yes, ma'am.
And you know that to be the truth?
Yes, ma'am.
That's all I have. Can you tell the court your name?
Caitlin Newland.
Miss Newland, how do you know Miss Tackett?
She is a family friend.
And do you know her to be truthful?
Yes, ma'am.
And you heard everything she testified to today and know that to be the truth?
Yes, ma'am.
All right. If will be awarded an absolute divorce, she'll be restored to her maiden name, or she doesn't have a maiden. She's
You
not
do a name change.
adopted that married name. And anyway, she'll be awarded a divorce on the grounds of inappropriate marital conduct and awarded all the property in her possession. Each of them will pay their own debts.
Thank you, Your Honor.
Okay. Yeah. Good morning.
Here for the plaintiff, Mr. Newsom, said petition to amend the final decree of divorce. Divorce was finalized by agreement, irreconcilable differences back in March. Part of that marital dissolution agreement divided a retirement account.
Well, I think we may be on a different case than what you were talking about. You're calling
It's called Newsom
Doris
versus Newsom.
Doris.
I'm sorry, I can't hear all the way over there. I'm about to relocate.
Try. Doris versus Doris. Tammy Doris versus James Doris. Ms. Brady, that's your case.
Good morning, Your Honor.
Good morning. This was reset for today, I think. I'm not sure exactly. I remember that Mr. Doris appeared when he was in custody, and it was reset for us to determine the distribution of real property owned by the parties and whether an award of alimony is appropriate. Should you amend your petition? Have you amended your petition?
Yes, Your Honor.
All right. Then you may put on your proof. If you'll raise your right hand, please.
I do.
Okay.
All right,
Miss-
let me stop you for a moment and state that you filed an amended complaint for divorce, which means we cannot grant your divorce today because he has 30 days from the filing of and the service on him of the amended complaint. So
Okay.
it restarts the time that he has to file an answer. So I don't know if that makes a difference in how you want to proceed or not. Has he been served without amended complaint?
It was sent to him in jail, so we didn't do like a summons or anything like that.
Once he was served, you can serve it by mail.
Right, and that's where we sent it to him in jail.
Well, let me just point out that when you file the amended complaint, which you have every right to do, and I understand why you would, and serve it on him, he has 30
Sure.
days to file his answer. So I can't grant a default.
Sure.
And I would suggest you just reset it for next month, and that way we can go from there.
I concur, Your Honor. All right, thank you.
What date? Let's go ahead and set a date, Ms. Brady.
Sure. That's fine. I'll get a date, Your Honor, and put it in the
All
order.
right. I'm on my third set of antibiotics for this, and we're still knocking it out. So, is that because of the air conditioning? Oh, you can't hear the clerk because I can barely hear her. She needs a microphone of her own. How about this? I will repeat the name of the case after she calls it to me.
That would be most helpful, Your Honor.
All right.
This is Miss Newsom.
Arthur Roy Newsom Jr. versus Donna Lee Newsom. Everybody hear that one?
Yes. Apparently, Ms. Newsom is here. Now that I've already briefed you on the case, we're here on a petition to amend the final decree that was done by agreement regarding a retirement account. Ms. Newsom was awarded $350,000 from my client's TSP thrift savings plan. However, that money was shifted to an IRA before the divorce was finalized, and therefore he cannot access those funds from first command without an amended final decree of divorce that I prepared. Ms. Newsom has signed an amended marital dissolution agreement. I don't think there's any opposition to this motion being
You
granted.
want your money, right?
It's taken a long time, and I'm getting overdrafts and all kind of things.
Well, we're going to try to take care of that today.
Thank you.
Biggs, I have signed this final decree, this amended final decree.
Very good. Thank you, Your Honor.
Hopefully that'll take care of you, ma'am.
Can I get one today?
There's a preliminary issue that the court has to address. My client had filed for the divorce. Ms. Tackett from Robertson County was representing the husband. I filed a motion to compel the discovery because they weren't answering it. Then on the same day I came to court on the motion to compel, his attorney filed and heard a motion to withdraw. The court allowed him 30 days to get a new attorney. I reset my motion to compel and did a motion to set for final hearing. Your Honor granted my motion to set for final hearing, and we set it for today. Last Friday, evidently, he retained Miss Tackett. Miss Tackett sent my office a message. It was Thursday or Friday. Forgive me, Your Honor. Sent me a message, said she was retained in us, and I said, have him sign the MDA. These parties have nothing but debt. That's all we're dealing with. And she then told me that she couldn't be here this morning, that she had to be in Robertson County. My client wants to get this done and over with. All they've done is prolong it. They've not done anything to get it over with. And him retaining an attorney and not even telling her it was set today within 2 days of the hearing is just not reasonable. So we're asking that her motion to continue it be denied.
One of the problems that I have is that I practiced law for a long time, and I know how sometimes these things act. I understand your need to get this thing heard, and I understand that there is very little to fight over, but I'm reluctant to take advantage of an attorney who's just been brought into the case. So I'm going to grant the motion to continue, but I will order that it be set for the first available date that you are available, and she'll just have to make her arrangements. If she can't be here on that day, then you will have the right to proceed, and she'll have to either find someone that's a surrogate for her, or she'll have to be here.
I understand, Your Honor. I'll get with the clerk.
All right, ma'am,
Thank
we're
you.
going to try to take care of it as quickly as we can, but I'm going to give them an opportunity to be here. All right, thank you.
Thank you, Your Honor.
Case number 19703, Pamela Mitchell versus Anthony Mitchell.
Pamela Joy Mitchell versus Anthony Keith Mitchell. I dropped down on my agreement to repeat that. It's here for an order of protection.
Yes, Judge.
Are we ready for a hearing?
We are, Judge.
Yes, Your Honor. And Your Honor, I hate to be difficult, but I can't see if we're going to use the witness stand.
Is it because you're short?
Well, Your Honor, for the record, opposing counsel is a lot taller than I am. So,
Well, Your Honor, we have our petition and Ms. Davis has filed a motion for continuance. She's new to the case. While we don't necessarily oppose a continuance, we just need to address the court on some issues because we need a parenting schedule going forward if the continuance is granted. And so I don't know how long the court would need to hear from us about that.
We'll need to, yes, if there's a motion to continue, then we need to, obviously, to address that. We have a number of cases that are set in front of you that are for a hearing. And I was just trying to determine the length of time that this case would take. But if it's a request for a continuance, tell me, what are you asking? If I understand correctly, Ms. Myers has relocated to another state, and Mr. Novak, who is here in the courtroom, is requesting, according to the file that I reviewed this morning, that some sort of a specific schedule be set for him to visit with his children out of state. Is that what I'm understanding?
Well, he would like to visit with the children in Tennessee. What he's asking for specifically today, Your Honor, is the 2 consecutive weeks of summer visitation that are in the parenting plan. We understand the mother is getting married and we understand she's going on honeymoon. The parenting plan provides for the right of first refusal for when she's going to be gone for more than 12 hours without the child. So we're requesting that time, just specific time between now and whenever the rehearing is, Your Honor. And then the issue of relocation, transportation costs and shared transportation has arisen. My client has done almost all of the transportation going to Ohio to see the child. So we're asking that that be shared in this interim time, that they meet in a halfway point.
All right, Ms. Davis, so you have any position on this? Obviously, is it you that's asking for a continuance?
Yes, Your Honor. I was retained last week on Tuesday. This case has got a lot of complications to it. The motion for contempt is very lengthy. I filed a response. I worked all weekend to file a response to the motion for contempt and filed it last night, which is not very much notice for anybody, and I apologize for that. But I haven't even had the chance to go through all of the information my client has sent me, which is voluminous messages between herself and the father. I'm in Davidson County this morning and have a final hearing on a child support matter that has not started yet. I think that even for the court to hear and to make on a temporary situation for parenting between the father and the child is going to take at least 2 to 3 hours. I do think that there needs to be a hearing. I do think that we need to do it sooner instead of later. But if you had the chance, and you probably haven't had the chance because it just got filed this morning, the child is 4. Father has had a total of 12 overnights with the child in the last 4 years. And there's been a lot of back and forth between the parties. They went to a mediation last Monday, were unable to resolve an interim plan. Father last had the child from July 10th to the 12th. 2 days has been the maximum he has ever exercised parenting time with the child. And I'm not here to stand for the proposition that dad's a bad person or dad doesn't love his child. I just think it's significant that my client has lived in Ohio for over 2 years, and this whole thing is just contested. So I don't think that to without any evidence and having a hearing, to think that sending the child on a 50-50 plan to Nashville with dad is a good idea. And there's a lot of reasons for that. And I respect, of course, Ms. Chesney's position. I know she's got to do everything she can for her client. I just need a little bit of time, and I've got plenty of dates. I don't know what the court schedule is, but I would love to be in person in front of you so that we can all be in the same room and we can have a hearing on this and make a decision that makes good sense for the child's best interest.
Well, this is here is a problem. We have a number of cases set on the docket that are advanced or ahead of you that are probably looking to take the rest of the day. And if your case is going to take 2 to 3 hours, then there's really a little way that it's going to be heard today anyway. And I am of the opinion that it needs to be reset. I can tell you that it looks like the first available day that is open for resetting. We have 4 judges that cover 5 counties. We rotate in and out on a regular basis. This concludes my days of chancery here in Cheatham County for 4 months. So it would be advantageous for you to get in front of another judge, since I haven't, to my knowledge, heard any of this before. And so I'm going to grant a continuance based on the fact that it's unlikely it's going to be heard. And I will simply observe that, and I will put this in the order that's drafted for the continuance. The final parenting plan that these parties agreed to is still in full force and effect. And that provides that they have 2 weeks of summer visitation, 2 consecutive, uninterrupted weeks of summer parenting plan. So if he has not had that this summer, he's entitled to it. And I'm in this order setting forth the fact that they're bound by a final decree and parenting plan that they entered into, and that will have to be a part of this order of resetting the case. So I can tell you that September the 11th is the first available date for a full hearing.
Sorry, Your Honor, just give me 1 second. Your Honor, would I be able to attend that hearing via Zoom?
It's a different judge. Would she be able to attend the hearing in front of Judge Lockhart Nash? You'll have to contact Judge Lockhart Nash's assistant. The other date she has is, what day? September the 30th.
Oh,
The 11th would be a much better day.
September the 11th works for me, Your Honor. And who need to contact?
Judge Lockhart Nash is the judge in September here, and you would need to contact her assistant, who is Kelly Berryman. I've looked to see if there's any open days that I could offer to you in some of these other cases, and I simply do not have anything open on my calendar. So we'll reset it for September the 11th, and again, this order should reflect that the court finds that the original parenting plan, which was adopted, is in full force and effect.
do you want me to draft that order, Your Honor?
Yes, please.
I will. And Margaret, I'll call you.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
Contact Sanks with your attorney so she can work out when you're going to have that visitation, okay?
Yes, sir. Thank you, Your Honor.
Thank you.
All right, let's call the next case. I would love to get rid of you, so come on up.
I thought you might like that.
No personal
I
animosity
know,
there.
and I don't take it that way at all, Your Honor.
Which case was it again? I'm sorry.
Osborne, it's on the next to the last page.
All right, what is your agreement?
Well, the income, the Pendente Light support, we're going to remain status quo. Everyone will continue paying what they're paying. Nothing's going to change.
Not moving any money, things like that.
Yeah, everything will continue on as it has. And as far as the motion for the educational testing, we've agreed that the children will take a standardized test. My client will be the proctor, and wife will not interfere. She will encourage the children to take tests, and any outcome of that test is reserved for a later hearing. And my client will get all this done within 30 days.
If that is your agreement, then we'll
Is there
approve that
anything that I
agreement.
missed?
I don't think so.
All right, thank you. Who's drawing the order?
I'll draw the one on the education.
I'll draw the one on the support.
All right, we'll have 2 separate orders.
Is that okay, or do you want them all in one? I can do them in
One
one.
would be fine too.
Yeah, I can do it all in one if you prefer.
Let's just do one order. That just seems to me to be more advantageous.
No worries. I will prepare it and forward it over to council for review.
All right, thank you.
Thank you.
Thank you, Your Honor.
Call the next case.
Your Honor, this matter will be relatively brief. This is just a certification of a will contest. My client, Jeffrey Mays, is an intestate heir of the decedent, and we are just asking that our will contest be certified. I've brought a proposed order.
Anyone objecting to that certification?
I've been in touch with the counsel for the estate. He doesn't object either.
Then if you'll submit your order, that'll be, is it at the circuit court for the trial?
No, sir. It's keeping it here in Chancery.
You okay with doing a jury trial? All right, I have signed your order.
All right. I appreciate it. Thank you, Your Honor.
So we go back. So we're ready for, I think, Ms. No and her case. If we had a Sears catalog, we'll have you sit on it. It might be helpful.
I'll try and bring a phone book or something next time.
This is the 2025 CR 19703 Pamela Joy Mitchell versus Anthony Keith Mitchell. It is a petition for an order of protection. Both sides are ready. You wish to make an opening statement?
I will briefly, Judge. This is our petition for order protection. The parties are married. They are going through a contentious divorce. They've been married for 53 years. The petition alleges that the husband has been verbally abusive, cold, and harassing. She also alleges stalking. He has showed up at places that he should have had no knowledge that she was at. They've also had a discussion about her placing a tracker on her vehicle, and she has the screenshot showing that there's an air tag placed on her vehicle. She at one point had a automobile accident in Davidson County, and it's going to be her testimony that the husband showed up at that scene of the accident before the police even did. There's pictures of him showing up at a friend of hers house and taking pictures of her vehicle in the driveway. While he was taking pictures of her vehicle, the security camera was taking pictures of him. So we do believe there's stalking going on, and this is elevated to the point where he calls multiple times a day, calling her a whore and slut and all this stuff. And one of the last voicemails says, "I hope you die." So it is escalating. He has numerous guns. She's afraid of him. So we're asking that the order of protection that was their ex parte in place, we're asking that it be continued as long as the divorce remains pending.
All right. Ms. Snow, you wish to make an opening statement?
Yes, Your Honor. Your Honor, the parties to divorce has been pending since May of 2025, so it's been over a year now. And Your Honor, I think it's kind of odd that no order of protection, no restraining order, nothing's been done until now. The parties had mediation less than or right at a week prior to this order of protection being filed. They were not successful in mediation. I feel that this order of protection is being done in a somewhat vindictive manner. A lot of the allegations complained of my client happened a long time ago when this divorce was first started. And I feel like to take out an order of protection now is just being done to be harassed. And my client, to be candid with the court, has maybe called her some names. And, Your Honor, I don't think it's the first divorce that we've ever heard somebody call their spouse a name. I don't think that gives rise to a level of an order of protection. The parties have grandchildren together. There's a birthday party that's being planned that is upcoming for one of the grandchildren, and I think this is being done so that he cannot participate or be in his grandchildren's lives. And I think this is just done in a vindictive manner. And again, it's been pending for over a year. Nothing's been done prior to this. And we do have a plausible reason of how he got notified about the car accident. The parties had joint insurance and got notified by the insurance company.
Judge, I called my client. She has voicemails that she needs to play. Can she bring her phone to the stand?
Yeah, she can bring her phone up there. There's a microphone on the witness stand. A little bit awkward. If you'll come right around here and have a seat, ask you to please stand and raise your right hand. Face our clerk. Thank you.
Just state your name for the court.
Joy Mitchell.
You see that microphone right there?
Joy Mitchell.
All right, pull it down to you. We still can't hear you.
Joy Mitchell.
Better. Okay. And how do you know the respondent in the blue shirt here?
We're married
Okay. How long have you been married?
53 years.
Okay. And what brought you to the court to file this petition for order of protection?
These 9 voicemails.
Okay.
They escalated. The last one said he wanted me dead.
Okay.
And
right.
I'm scared to death.
All right. I want to pass you a copy of something here. Do you recognize that?
I do. These are the copies of the emails on my phone screen.
Is that your call log?
Yes.
All those calls on the same day?
Yes.
Okay. And I'm going to also pass you.
On June the 27th.
Okay. And that's of this year?
Yes.
And what is that?
That's the call log.
Is that the screenshot of your voicemails?
Yes.
Okay. And are all those voicemails from your husband?
Yes.
And 1, 2, 3, 4, 5, 6 voicemails in less than an hour's time. Is that correct?
9.
9 voicemails?
Mm-hmm.
Okay. Can you
The
play?
others were on a different page.
Okay, I'm sorry. Judge, can I make these first exhibit collective? Thank you, Judge. Ms. Mitchell, do you have your phone there in front of you?
I do.
Can you play those recordings from the first to the last one?
Yes, sir.
Okay.
I can.
Your Honor, I am going to object. We had discovery that has been sent, and these were not supplemented or provided to me in the discovery, so I'm going to object to their introduction today.
That's for the divorce case, Judge.
It is a separate action, although it's been consolidated with the divorce action itself. And my understanding is on an order of protection, it's not necessarily required that they be provided to you in advance of the hearing. So I'm going to overrule your objection.
Thank you, Judge. Can you go ahead and play them from the beginning to the end, and just tell us when one ends and the next one begins if it's not evident?
All right.
and put the phone up to the microphone.
Hey, road whore, call me back.
Is that the first one? Is that the end
That's
of
the first one.
All right, let's play the second one, please.
Hey, road whore, answer your phone, you fucking slut. Suck you, I hope you die. Hey, road whore, are you fucking David Berry 2 years ago? You piece of shit. Hey, bitch, who's David Berry? Are you fucking David Berry, road whore? Was you fucking 3 years ago? You bitch. Are you fucking David Berry, road whore? Was you fucking 3 years ago? You bitch. Hey, road whore, you called David Berry before you ever left me. Who's David Berry, road whore? 1 a.m. in the morning.
Are those all of
Let's
them?
see.
Judge, I would ask that those recordings be made as a collective exhibit. I have them on a flash drive to make it easier for court.
Mark them as Exhibit 2. Just hand that to the court.
Now, Ms. Mitchell, I think you may have played some of those out of order by the call log. Was the last one he sent you the one that says, I hope you die?
That was the fourth.
The fourth one?
The fourth.
Okay,
one.
I'm sorry. When he said he hoped you die, how did it make you feel?
And Your Honor, for the record, I didn't get a copy of the flash drive, just to have a copy of the same evidence. It made me feel.
Same basis for the overruling of the objection. This is an order of protection, which is an extraordinary remedy, and therefore I'm allowing this evidence for that reason.
And Judge, just for the record, I want to make clear, I told Snow about these this morning and told her that I was going to play them. She never once asked me to listen to them.
Kind of moved the day of, so.
How did that make you feel saying he hoped you die?
Well, it's a sad state when you've been married to somebody for 53 years and they can treat you that way.
Did that put you in fear?
It does.
Um,
And he has a gun safe full of guns.
Okay. Has he been violent with you in the past?
Yes.
Okay. Tell the court about that.
He's pushed and shoved.
Okay. And did that put you in fear of him?
Yes.
Okay. Has he ever hit you?
Yes.
Okay. And when was that?
It's been a while.
Okay.
I don't remember the exact date.
But because of him being violent in the past, are you afraid of him now?
Yes.
Tell the court about the stalking. He's put trackers on your car?
I know he has because my iPhone told me that I was being tracked, and it even showed me where he was tracked. I was at the Veterans Cemetery putting wreaths on the veterans' graves
Sorry.
in November.
Those are the same thing. One was for the witness. I apologize. There should be 2 copies there. Thank you. Do you recognize that?
That was the screenshot of my cell phone where I was being tracked at the Veterans Cemetery putting wreaths on the veterans' graves.
Now, this says it's from December of 24. Is that correct?
Okay, yes.
Is it? Okay.
I was thinking it was November, but it was December.
Okay. Judge, can I mark this as the next exhibit? I think it's 3. Now, has there been other times since then that you and the husband have had conversations about him tracking you?
When I was notified by my phone of this, I was concerned because I didn't know who was doing the tracking. And so I spoke with my children, and they said that
Don't tell us what the children said. I'm asking you, have you had a conversation about a tracker on your vehicle with your husband?
yes, and
Okay.
he bold-faced told me 3 times he had not done it.
So what did you do?
I was going in the house to get my purse in order to go to the West Nashville precinct to see if they could get the tracker out.
And what happened?
I called and they don't do that sort of thing.
When you tried to leave, did something happen?
He stuck his arm up in the back end of the car
And
was going to pull something out.
and when was this?
It was after I was notified. It says it's December the 15th.
So this was at the same time as this notification?
It might have been the day after because yes, or same time.
Okay. Now, have there been other incidents where you would be at someone's house and he would show up?
Yes.
Okay. Tell me about that.
I was helping a friend decorate his Christmas tree on Thanksgiving Day.
Thanksgiving of this past year?
Yes.
25?
Yes.
Do you recognize that?
It's my husband taking a picture of my car.
And where was this at? The friend's house?
Yes.
And did you tell him you were going to the friend's house?
I did not.
Y'all were already separated at that point, is that correct?
Yes. We had been separated since
June the 1st, the day or second, the day that he was served.
Would he have any knowledge, any way to know that you were at this friend's house on this day?
Not unless he had a tracker.
And is that him in the car?
It is.
Okay. And
That is his car.
okay. Judge, it has to be marked next exhibit 4. How did that make you feel where he showed up somewhere that you were without you telling him?
I didn't have any idea how he knew I was there or why I was there or why he showed up.
Did that make you afraid of him?
Yeah, because I felt like he was stalking me.
All right. Now, you heard what I said in the opening about the car wreck. Tell the court about the car wreck. When did that happen?
It was on March 13th. I had driven all the way back from Florida that morning, and I was going around a cul-de-sac. I had just left a Mexican restaurant, and I was going back to my apartment. And I was going through a roundabout thing, not a cul-de-sac, roundabout, and a car hit me.
Okay. And did you call the police?
I did.
Okay. And did your husband show up at that wreck?
He did.
How soon after the wreck did your husband show up?
Well, he got there before the police and the wrecker.
Okay. Did you find that odd?
I did.
Okay. Approximately how long after the wreck was it before he showed up?
15 minutes, maybe. It wasn't even that long, maybe.
Okay. And how far away does your husband live from where you had the wreck?
A good, at least 7 to 10 minutes, maybe.
Okay.
He lives in Pegram, and the wreck was in Bellevue.
Okay. So it is possible that if he were at home, that he could have made it to the wreck from the time the wreck happened, and that was 15 minutes.
Maybe.
Okay. Did he make any comments to you when he showed up at the wreck?
No, a friend of mine stepped in front of him.
Okay.
To separate him from me.
Okay. What do you mean by that? Was he coming towards you or what?
He was trying to get in the door, and my friend is rather large, and he stepped in front of the door to keep him from coming in. And my friend was kind of upset with him because he said he was trying to get in to see if I'd been drinking, because it happened right in front of a pub. And I went in because my friends were there. That's where they'd gone. I was on my way home. And they went in there, so I knew that one of them could give me a ride home.
So after the wreck, you went into the pub?
Yes.
And waited on your friends?
Yes.
Okay.
Because they were going to give me a ride home because the car was inoperable.
So how far
and we
from
had to wait for a tow truck.
How far from the scene of the wreck was the pub?
100 feet.
Okay.
Mm-hmm.
When he came to the wreck, he then came to the pub?
Yes.
How did he know you were in the pub?
I have no earthly idea.
Okay. Has he also threatened to damage some of your property?
He has damaged some of my property. He burned a welcome sign that was on the patio. I found the other half of it in the burn barrel. And then there was a sign that said "My Happy Place," and he bent it half in two.
Just so we're clear, you said the wreck was in March. Was that of this year?
Yes, sir.
Do you recognize those text messages?
I do.
Okay. Tell the court when these are from.
I don't know exactly. I would have to look back on my phone and see.
Judge, can she do that?
If I
So she
still
can
have that on my phone.
look back and
So
see.
you asking for her to be able to consult her phone?
Yes, to refresh her recollection, Judge.
She may refresh her recollection.
I'm not able to find that email
Well, it wouldn't be email, it'd be a text.
message.
Read through the messages. Do you recognize this as him talking to you?
Yes, it is, because I was the one that texted him wanting to know if he would put my mail in the mailbox.
Can you read those messages for the court?
Put my mail in the mailbox. I'll pick it up on my way to the chiropractor at 2:45 to 3:30-ish, or can pick it up on the way to Friendsgiving in Kingston Springs, your choice, which will be a little before 5:30. I have some of your stuff sitting outside the fence. If you pick them up today, I will have some of your clothing sitting out tomorrow. Okay. I'll get the rest when I have a truck. The love seat does not fit in my car, and you need to put the 2 chairs out there that go with it. Hey, Skank, this is my new target for tomorrow morning. It goes to the landfill in the morning. And then I told him that I sent this text to my lawyer. If you destroy my stuff, you're going to pay for it. And then he said, fuck you and your retarded lover, Larry, whore. I have never had sex with him. I have a contract to pay him back the money I borrowed to get the divorce. And then he tells me I'm not.
Well, don't tell. Just read it. Just read it. No commentary. Just read it.
You are a goddamn liar, you worthless piece of shit. You fucked everything with a hard dick. Then I had ED. You're Bellevue's biggest whore, and he spelled it wrong. You worthless piece of shit. You fucked everything with a hard dick. And then I told him that I was the only person. You are the only what? The only one I fucked this night while you were at work. You got home after late so I could fuck anyone after 11 or 12:15, and you did. No one can save you now. And I informed him that everything I typed is in blue. You typed that. I guess you forgot what you were going to say. And he says, you're a lying road whore. You licked his dick. How does size asshole taste? Besides, that's the only place his dick has been besides in your mouth. And then he says, I have your magazine basket sitting on the patio with a box of your magazines. If you have any time today to pick it up, pick them up and have a short talk without losing your temper. Text me back. Sorry, I just saw this. There's no way you can live without your phone for 20 minutes. Did you just get out from under your gang?
Now, Ms. Mitchell, it says there that he's want to have a conversation with you if you could not lose your temper.
That's what it says.
Based on this, does it look like you're the one with the temper problem?
Not to me.
Okay. Judge, can I mark this as next?
Exhibit 5.
Now, Ms. Mitchell, in those first texts, he was talking about using something for target practice, and there's a mention, you mentioned him destroying your property. Has he destroyed some of your property?
The love seat that I got back, it's burnt on the back, and that's a picture of it. It's burned.
What are those other pictures there?
A picture of the kids Connect 4.
Okay. Why is that relevant? I don't know anything about Connect 4, so is that damaged or broken somehow?
He left it so the weather could get it. I had it on the other side of the patio, so it was destroyed.
What are the next two pictures of?
Oh, that was the things that he gave me back were kids' toys that my grandkids have outgrown.
But the only one of any damage is the first picture?
Yes.
Judge, I'm sorry. Can I tear off those last three? Only admit the first one.
Would be 6.
And those text messages that you read, does he text you like that all the time? Just harassing?
He has.
And are you afraid of him?
I am.
Okay. Are you asking the court to extend this order of protection?
I am, because I don't want him. I mean, Tennessee's the #1 state for women dying, men walking through.
I'm going to object to, she's not an expert about domestic violence, and ask that that comment be stricken.
And what was your answer? I'm sorry. What were you saying?
That
he asked if you were afraid of it, right?
Yes, I am.
I sustained anything beyond that.
Are you also asking the court to award you your attorney fees for filing this petition?
Yes, because he started this.
Judge, those are my questions.
No, you may cross-examine.
You had talked about the AirTag and produced a picture. And I want to make sure I understand your testimony. This was in November of 2024, is that correct?
Correct.
So it was almost 2 years ago.
Yes.
Okay. And then the picture of whose house were you at? The picture from November of 25.
A friend of mine.
Okay, what is your friend's name?
Larry.
What is Larry?
Minnick.
And is that somebody that you're romantically involved with?
No.
You haven't had any kind of relationship with him?
I did when I was 14.
Okay.
We dated.
Okay. But he's recently given you a substantial amount of money, is that correct?
He gave me the money to get the divorce, yes.
Okay. How
And
much?
it's a loan.
All right. How much has he given you? Or loaned you?
$15,000 for the divorce.
Okay. Any other money?
From time to time, yes.
All right. And how much are we talking?
Don't really know. I've not kept a record of it.
So he's loaning you this money, but you haven't kept up with how much you owe him?
I've kept up with what I owe him.
So that was November of 25. That was almost 8 or 9 months ago. Is that correct?
It was in February of 2025, I think, because that was how I was able to hire the attorney.
But the picture that you testified to was November of 25. Is that correct?
Correct.
And then the text that you
It should have been
provided,
November of 2024.
November 24?
Yes.
Okay. And the text that you provided, you don't have a date for those?
June 26th.
No, I'm sorry. Let me clarify.
Okay.
The text that you introduced.
Those texts, I do not have the date because all it says is that it's on I think it said Saturday. Let me look. No, it says Tuesday at 12:31 p.m. And then it doesn't say the date.
All right. It also states in there, you text that you are on your way to a Friendsgiving in Kingston Springs. Is that correct?
True.
So this would have been in around November. Friendsgiving is celebrated in
Right.
conjunction with Thanksgiving. Is that
Yes.
correct?
Yes.
So this would probably coincide with the other events that happened in November of 2024. Is that correct?
Possibly, but it could have been 2025. I don't know.
Okay.
Because it doesn't say, I don't have a complete timestamp on it.
So you don't know if this was, it was either November of 2024 or November of 2025, but you're not sure which one. Is that correct?
I think it was 2024.
Okay.
But I'm not sure.
Which would go in conjunction with these other complaints that you have. Is that correct?
Well, not if it was 2025. Like I said, I don't really know the timestamp on this one.
Okay. But you complained about the air tag. That was November of 24. You complained about these text messages and then showing up at your friend's house, which was November of 24.
Showing up at the friend's house might have been 2025.
You just testified it was
Okay, 2024 then.
the picture on the couch. You have no idea what happened to the couch, do you?
It's burned. I don't know how he did it.
Okay, you're just assuming that he did that to be malicious. Is that correct?
Well, it wasn't done before I left.
Okay, but you don't know what happened to it.
I do not.
Did you take out an order of protection in November of 2024?
No.
Okay. Did you take out one in November of 2025?
No.
Okay. Did you take one out in March when you had the car accident?
No. I didn't until he wanted me to die.
And so you took the text, or you took the order of protection. You didn't take it after the incident that you received the text on June 27th. Is that correct?
That was what made me get the order of protection.
But you didn't take it out the next day or the day after that, did you?
No, I was working.
You were working. Okay. Is it coincidence that you took the order of protection right after we had mediation that did not settle?
No, that had nothing to do with it.
Okay. You attended the mediation, is that correct?
Yes.
And we had that in Miss Salinas' office.
Yes.
Okay. And did you ever tell the mediator or anyone else that you didn't want to participate in the mediation because you were scared of Mr. Mitchell?
No,
Objection,
because I was
Judge.
already told that we were going to
Objection,
be in
Judge.
separate rooms.
Sorry. There's a confidentiality signed regarding the mediation. They're not allowed to
Anything
discuss.
that occurs in mediation is confidential and cannot be introduced in court. So.
And Your Honor, I'm not trying to introduce what happened in mediation. I'm just establishing the fact that she was there and she participated in person in mediation.
And that's been established. I sustain the objection as to anything else.
Okay. The mediation was on July 1st. Is that correct?
Correct.
Okay. And then the incidents with the text were June 27th. Is that correct?
That is correct.
And then when did you take out the order of protection?
I believe it said the 19th it filed.
So you waited approximately 3 weeks. Just a second, Your Honor. Looks like you signed this either July 8th or July 9th. Does that sound correct?
It does.
Okay.
I believe it was, I signed it the 8th and it was signed that afternoon and I got the copy the next day because I had to drive back over here to pick it up.
Your Honor, there's a little discrepancy on the order of protection, just for what it's worth. It shows it's filed July 8th. However, her notary signature is July 9th, so I'm not really sure what date it actually was because there's some discrepancy on the date of the petition.
They signed it that afternoon and I had to pick it up the next day and that's when the Chancery Court woman signed it and gave it to me.
So you took it out several weeks after the incident with the text on June 27th and roughly a week after mediation. Is that correct?
Yes, I believe so.
That's all I have, Your Honor.
Redirect.
Just briefly, Judge. Ms. Mitchell, after the incident happened on the Thanksgiving, or what it was, you were at your friend's house and showed up. Did you recall emailing that to me? That
I
picture?
do. I do.
And Judge, can I pass her the original that had the timestamp on it?
Sure.
Can you read that for the court? What date and time that is? It's in the top left corner.
Yes, it is 11/27/2025.
Okay. So the date that he showed up at your friend's house was this past year, not 24.
Yes,
Okay.
that is correct.
Okay.
I was actually on the telephone with a friend of mine talking to her.
Judge, that's all I have.
Anything further?
Nothing further, Your Honor.
Ma'am, you may step down and seat at the table.
Judge, that's our proof.
But plaintiff has rested their proof on the order of protection. Ms. Snow, do you wish to offer any proof?
Your Honor, I'd like to call Mr. Mitchell.
Right. Mitchell, if you'll stand and raise your right hand, face the clerk to be sworn in.
Mr. Mitchell, you've heard your wife testify, and I'm going to follow up with some questions that she testified to. Have you ever hit your wife?
No,
And she indicated that you had, but didn't give any details and couldn't remember any dates.
I have never struck my wife.
Have you ever shoved or pushed your wife?
Yes.
Okay, tell me about that.
She was pushing on the gate and she was beating the gate on my arm and she bruised my arm and I got tired of her banging it against my arm and I pushed back and banged on her arm for a little bit.
Okay.
So I just returned what I got.
Have you ever instigated or done anything to push her or shove her in which you were not in a position where you were trying to defend yourself?
No.
Let's talk about some of the things she testified. She had introduced to the court a series of texts and that where you were discussing she's picking up some things and that she's going to be in Kingston Springs during Thanksgiving. Do you recognize those texts?
Yes, I do.
And did you look at your phone to see when those texts were done?
Yes.
And when were those?
In November, the first text that I on that list was November the 11th. The next text was November the 17th after I found out who wrote her the check for $15,000.
And that would have been a 2024, is that correct?
Oh, I'm sorry, hold on a minute. It's 24, yes.
Okay. And you were upset, is that correct?
Yes, when I found out that she had been seeing her old boyfriend and her sugar daddy, Larry Minnick, who I graduated with, I was totally shocked.
And do you regret sending some of the verbiage that you sent to her? And did you ever threaten her or did you ever mean any harm by doing that?
I did not, I have never threatened her. I mean, yeah, I said, I hope you die, but hopefully of nothing that's by violence. I just was hoping she'd have a heart attack or die of guilt or something.
All right. You've been upset during this divorce, is that correct?
Very upset. She's been cheating on me after 51 years of marriage, and according to some of the phone things I found out about Barry, she was cheating on me before she ever left the house.
So some of this information, you found out about the $15,000 check that Mr. Mimic had given her. We had just gotten that in our discovery. Is that correct?
Yes, ma'am.
And then you found out about, and I apologize, the other gentleman's name, but we had gotten that when we subpoenaed phone records. Is that correct?
His name and about 3 other guys' names.
And that's when you sent her the text on June 27th. Is that correct?
June 27th started off as not sending bad texts. She sent a full of flags and things back from my 4th of July decorations, and she had wadded them up, stuck them in there. I texted or called and asked if we had an iron because I couldn't put anything up that looked that bad. And she said, we don't. And then she started argument escalated for the rest of the day.
Okay. So was this argument one-sided on your behalf, or was it also arguments from her?
She's the argument, and she has a real big thing about not answering her phone or stuff when I come.
So I cannot tell you exactly how the argument went on the text. It was both sides.
Has she called you names in the past?
Yes. And she's told me she's hoped that I died in the past. I've got a recording of it on my iPad.
Do you have that with you today?
It's right there.
Can you find that fairly quickly?
I'll try. I believe it was April the 11th of, I'm sorry, I can't find it right now. I'll hunt for it to represent that.
Okay. Do you believe that was April, you said the 11th of 25?
Of 24. It was before she left because that was about, I'm thinking that was the day where she banged on me and I banged the gate back.
Okay.
Or the day after or something like that.
All right. And Mr. Mitchell, you provided me a copy of your calls where you're on the 27th. Is that correct?
Yes.
And we're showing 1, 2, 3, 4, only 5 calls. Is that correct?
Yes.
Okay. And you were only on there for less than 30 seconds on each call. Is that correct?
That's correct.
Okay. And you were upset that day. Is that correct?
Yes.
Okay. And did you leave some voicemails that perhaps you should not have left?
Yes, I did.
And do you have any intention on harming your wife?
No. I have never harmed her in the past and never planned to harm her.
And can I make that as an exhibit to your testimony?
Yes.
Mr. Mitchell, I'm going to kind of go back a little bit. Looks like the first thing that Ms. Mitchell complains about you is in November of 24. This is when she claims that there was a tracker on her phone or on her car, and these initial texts went out. And were the two of you still married at that time?
In 24, yes, we're still married today.
Right.
Yeah, we were married then.
All right. But a divorce complaint for divorce had not been filed by then. Is that
No,
correct?
it didn't get filed. I never received papers till June the 2nd.
Of 2025?
24.
24. Okay. And are you sure it was 24 or not 25? So y'all were still together in November of 24. Is that correct?
Yes.
And because I know her attorney is going to ask you, so I'm going to go ahead and ask you, did you put an air tag on your wife's car?
I did in December of 24.
And then you took it off immediately. Is that correct?
I didn't know an air tag would rat you out. I had no idea that it would tell her that there was one there. I was trying to find out who she was spending 5-6 hours a day with throughout December. I put it on there because I knew that she was going to take her walk and then she's going to spend some time with somebody.
But you immediately took it off. Is that correct?
When she confronted me, I waited till she went inside and I took it off.
Haven't had an air tag or followed her or done anything since then. Is that correct?
No, I haven't followed her or got an air tag or anything.
Okay.
Oh, let me back up. Yes, I did follow her one time on the 1st of this year. Me and my grandson were mailing her alimony check. I've got pictures of me putting in the mailbox. We pulled on Highway 70 and somebody in a gray SUV, some woman shot me a bird and my grandson was sitting in the car. I followed the vehicle less than a mile. I got behind it and it was her. She shot us a bird. So she was provoking things that didn't need to be provoked. And as soon as she turned toward Kingston Springs, I went across the railroad tracks, did a U-turn and came home with my grandson.
Does she provoke you a lot?
Every chance she gets. She knows what buttons to push.
Let's talk about the car accident. How did you find out that your wife had a car accident?
My insurance company informed me.
Okay. And was her vehicle did y'all have a group policy back in March of this year?
She was on my policy. It was the same policy, yes.
And who was your insurance with?
Safeco.
And how did they notify you?
They text me.
Judge, I
I
object
think it's for the judge.
to this. It's not authenticated. It is not a business record, or an authenticated business record, and it's hearsay.
What is it?
Your Honor, that my client can testify that he received from Safeco that there was a car accident.
Well, I think the text itself is hearsay, but if it's being introduced to show for a purpose other than admitting its truth, in other words, there's no question about it having been a car accident, So if you're admitting it to show why he took certain action, I'm going to overrule the objection simply because it is clearly hearsay. And I'm allowing it only to allow her to question Mr. Mitchell about why he took certain actions. If it's being introduced for a purpose other than to prove the truth of the matter asserted therein, then I think it would be admissible.
And Judge, the other issue is it doesn't say when he received this text message.
And I think that's the subject of cross-examination. Right.
Mr. Mitchell, is this the text message that you received from Safeco Insurance Company?
Yes, it is.
And is there a date on there?
Yes, the 13th of March.
Okay. And do you recall, does it have a time that you received this text?
I'm going to say the time's between 9 and 9:15.
Okay. There is at the top, it says 10:37. Is that just when you took a screenshot?
Yes, that's when I took the screenshot of the text.
All right. But you received that around 9 to 9:30 p.m. on March the 13th of 26.
Well, it was before, it was between 9 and 9:27.
Okay.
Because at 9:27, made a call.
Okay. All right. And so you received this. Were you concerned about what had happened?
Yes, I didn't know anything about it. I didn't know if she was hurt. I didn't know where the wreck was. I didn't know if she was being transported to a hospital.
And did you attempt to call your wife?
Yes, I attempted to call her at 9:27 after I got this text.
Your Honor, can I make that as an next filed exhibit, please, to his testimony?
You would have had that.
Yes, sir.
Mr. Mitchell, is this a screenshot from your phone where you attempted to call your wife at 9:27 on May the 13th of 2026?
Yes, it is.
And did she answer?
No,
So you did not know at this junction if she's hurt, if she's in the hospital. You don't know anything. Is that correct?
I just know that her vehicle was in a wreck.
Were you concerned about your wife's safety?
Yes.
And Your Honor, if we can make that as the next exhibit to the testimony. So, Mr. Mitchell, when your wife didn't answer her phone, what did you do then?
I went to the computer and I got on the computer and was able to find a page under Metro Police, under Metro Government. I don't know if it was the police, but it told all the wrecks that was around at the time.
And your wife was living in Bellevue, is that correct?
Right.
So were you looking all over Nashville or did you limit your search to Bellevue area?
I limited my search to Bellevue.
And did you find some car accidents in Bellevue?
There was 2 accidents. One was on Old Hickory Boulevard, close to the interstate, and the other was Brown and Todd Priest, right in front of her local bar.
And is that where your wife, to your knowledge, spent quite a bit of time?
I'm sorry?
Does your wife spend a lot of time at that location?
A whole lot of time.
Did you then call the Metro Police Department to check on the status to see if they could tell you if your wife was okay?
Yes, I did, and they told me that
You can't tell us,
I can't repeat what they told you. Oh, sustain the objection.
based upon the information that they gave you, did you go out to where you thought the scene of the accident was?
yes.
Okay.
No, I did not at that time. Shortly thereafter, I was informed that they'd been there. I got in the vehicle and I decided to go up to the Plantation Pub and see if I could find any witnesses to the wreck.
And this shows that you made the 615-862-8600. Is that the telephone number you called for the Metro Police?
Yes,
And it looks like, according to your screenshot, you did that on March the 13th. And you did one at 10:22 and one at 10:29 p.m. Is that correct?
that's right.
And can we make a copy of this as an exhibit to your testimony?
Yes,
Your Honor, do you already have his copy? Do you have that? Okay. Again, Mr. Mitchell, were you concerned about your wife's safety?
yes, but I was not as concerned because I'm not allowed to testify what the police told me, but there was no injuries, is what I was told.
All right. So you just wanted to check to see what the status of the vehicle was. Y'all had a joint policy, is that correct?
Right,
And so her vehicle was insured on your policy.
yes.
So you then went to Bellevue, is that correct?
Correct.
Did you get there? Were the police still there?
No,
Okay. So the accident had already been cleared?
the accident had been cleared. There was a front end of a Lexus laid in the middle of the roundabout.
And your wife does not drive a Lexus, though. So you're assuming it was the other vehicle.
Absolutely.
And there was testimony that you went to the pub. Did you tell me why you went to the pub?
I went into the pub and went to the corner where people sat outside. There was nobody outside. The screened in area, there was a couple sitting there. I asked them had they possibly witnessed the accident, and they did not. I asked another couple right inside the door, and they had not witnessed anything. Then I asked one of the servers if he had seen anything, and he said, "We've been so covered up, I hadn't seen anything."
And then you saw somebody that you mutually knew, is that correct?
No, I went to the door to leave. When I got to the door, I heard a voice way in the distance, and that was her running buddy.
And did you ever talk to her that night?
No, I did not.
Did you leave right then?
No, but when I looked over there at the woman speaking very loudly, Chuck, my son's stepfather, was standing at the door. The one she said was her big friend. And he said, "Hey, Keith, how you doing?" And I said, "I'm fine." I said, I was just leaving. He said something about, well, she's over there with Joni.
Hearsay, Judge.
Sustain the objection.
You can't tell us what he stated to you.
Chuck did not block me from her at all, but I was leaving, and then I saw her and Joni get up, heading toward the door. Before they got to the door, I went outside, stepped off the sidewalk, and turned around and looked at her. And they was all standing inside of the door, and I never spoke a word to her. Didn't know she was there. I can't imagine somebody going into a bar after they just totaled out a couple of vehicles. And I'm sure she had been to the Mexican restaurant. I think that she said they probably had at least 4 margaritas before she left
Objection
there.
calls for speculation.
Sustain the objection. You can't hypothesize about what you think she might have done.
So you left and home, is that correct?
Yes,
Okay. We had mediation on July 1st, is that correct?
yes,
Okay. And your wife was there and participated, is that correct?
yes.
And you didn't know anything about this order of protection until I called you, is that correct?
Right.
Y'all share grandchildren together, is
Yes.
that correct? And is there a birthday party that's coming up?
Both of my grandsons have birthdays next month, on the 14th and the 18th.
And do you think she is doing this to keep you from participating in that?
Objection calls for speculation.
Sustained.
Tell me why you think she took out the order of protection.
To keep me from my grandson's birthday parties that my daughter said I figured she'd do this.
The same objection.
It's hearsay.
Sustained.
All right, Mr. Mitchell, you saw this picture with a couch. Do you recall seeing that this morning?
Yes.
Tell me what happened to the couch.
I know my wife has no idea what refraction is. We have a basketball goal that has a gigantic 1-inch thick plexiglass backboard, sits at the patio. The couch was sitting under there, and it burnt. When I went out and saw that it was burnt, I had no idea how it happened. I moved it, and a few days later, I had another chair sitting there with a cushion, and it was burnt. So I started doing some investigations and saw that the refraction from the basketball goal, I went inside and got a thermometer, and it was only like 83 degrees outside. And I laid the thermometer on the concrete where the light was being reflected to, and it was 105. And may have, let me see if I can bring that picture up, that the sun did this damage.
And the couch was outside because she was getting ready to pick it up. Is that correct?
Yes, yes.
And you didn't do anything intentional?
I did not burn the couch. I have a rate thermometer that I use when I'm barbecuing, and good grief.
Mr. Mitchell, okay, you've testified to that, but you looked at the thermometer and just to see if that's what caused it.
On the 88 degrees, the thermometer read 105 degrees where that light hit it. I got it right here. Can I show this to the judge?
Yes. And then if you,
What caused you to do that?
Pardon?
How did you take a picture of a thermometer on that particular day?
Because I'm trying to prove that she already accused me of this, me burning her couch. I didn't do it.
So
And when I saw the light right there, I said, "That's what's done." That's why I was there. And this day was, well, let's see, but where that X crosses, Your Honor, was the hottest spot in the concrete.
you couldn't figure out how it got burned and you were trying to investigate that. And then you testified that another chair, an
Right.
outdoor chair that had upholstery had gotten burned as well. Is that correct?
Right. It wasn't quite as bad as the picture, the first one there, but that was earlier in the summer, in late summer, in August or something.
Mr. Mitchell, do you have any intent on harming your wife?
No, I do not.
And do you have any issues staying away from your wife?
I just can stay away from her forever.
You would like to be able to participate in family functions.
I keep my grandchildren every week. I'll have both of them tomorrow.
And do you feel like a lot of these complaints that she's making are things that happened almost 2 years ago?
Yes, she's been cheating on me for a long time, and that created all the name calling, all the anger.
Do you feel like you have a control and those are no longer an issue with you? Your anger, do you feel like you said brought a lot of anger? Do you have any anger? Do you feel like that's still an issue, or do you feel like that was something that happened almost 2 years ago?
That happened. Well, I can't be honest and say I'm still not angry. I really don't want to have anything to do with her, but I plan on having everything in the world to do with my grandsons.
All right, that's all I have, Your Honor.
Williams, you may cross-examine.
Thank you, Judge. Mr. Mitchell, you keep saying that your wife's had an affair. She's adamantly denied she's ever had an affair, has she not?
She's always denied it.
Okay. And you admit now in court that you stalked her. You placed an air tag on her car, correct?
Right, and I had plenty of good reasons. I have many days in December where she would use her lubricant and go out and be gone 5.5 to 6 hours every she left.
Okay. Are you aware that it is against the law to track someone without their consent?
I had no idea.
Okay. And after she confronted you, then you went and took it off.
Yes.
So if she hadn't confronted you, you would have continued to track her, correct?
I wanted to find out who she was with so
Is that a yes? You would track her if she had not confronted you?
Yes.
Okay. And you came to this person's house on November of 25, correct?
November 27th of 25, Thanksgiving Day.
That's you in the car.
That's me in the car.
Taking pictures of her, correct?
Right.
Okay. How did you know she was going to be there?
I didn't.
So you just showed up somewhere that you thought she was going to be?
It's like this. I was cooking supper for my children for Thanksgiving dinner. Needed something. I ran to Kroger's. Kroger's was closed. I just started to leave Kroger's, and I thought, she's over with her sugar daddy's house right now, which is Larry Minnick, the one who gave her the money to pay you, the one who's given her $40,000.
This person's house, this is his house, correct?
That's his house.
You pulled into his driveway, into his backyard, correct?
Yes.
Okay.
That's the only way I could prove it's her vehicle. I got a picture of her vehicle through the woods, but I could not prove that it was the same vehicle.
You got a picture of her vehicle through the woods?
So I was on the road behind the house. So I had to drive in the driveway to take a picture to prove it was her.
Did you have permission from the owner to be on his?
I gave him permission for anything, no.
Okay. So you're just going to trespass to follow your wife?
What do you mean trespass? People come to your house, knock on the door all the time.
Okay. You think it's appropriate for you to pull into someone's backyard and start
Yes,
taking
to
pictures?
to prove that my wife is in there having sex with Larry Minnick. Yes.
You have absolutely no proof that she was having sex with anyone, do you, sir?
Well, I think I do.
Do you have?
She has all of a cheating wife.
Okay. Mr. Mitchell, you sound very angry. Would you be angry?
Yes.
Okay. And do you understand how when you're anger and you accompany that with the words, "I hope you die," you understand how that could put your wife in fear?
No, it doesn't put her in fear because she said it to me.
Okay. And where'd you get the air tag from that you placed in her vehicle?
Best Buys.
I'm sorry?
Best Buys.
Okay. Have you tracked her prior to that?
Never.
Okay. Did you have a tracker vehicle this year when she had the car wreck?
Absolutely not.
Well,
I touched her vehicle.
Okay. You testified it was the bar she hangs out at all the time. How do you know she hangs out at that bar all the time?
I've got friends that tell me.
Okay. So you and other people are following her as well.
I do.
You have other people that are telling you her whereabouts?
Everybody knows her whereabouts. She runs with her loudmouth women.
And you admit that you showed up to that wreck and you said that you didn't know she was okay. Is that what I heard you say?
No. I showed to the wreck to try to find if somebody saw what happened.
Okay. So you didn't care about her well.
Yes, I did.
Okay. Did you ever ask her if she was okay?
She wouldn't answer the phone. Can I ask her?
Well, you were at the restaurant she was at. You saw her. Did you ask her if she was okay?
I stayed away from her because she's been claiming I've been following her for years. Not for years, for a year. And my daughter was expecting her to do this at this time, so I wouldn't come to the birthday parties.
Your attorney gave you an exhibit number 7, where is it testimony that this is all you called her this night?
I don't know if it is or not. It's all this number of calls that I looked off the exhibit.
Well, your call log doesn't start till 8:09. On your wife's call log, there were 6 different calls prior to this, all in the same hour.
Okay, I did not say that.
Okay. So you called her 9 times in less than an hour.
Okay.
Do you think that's harassing?
No.
You don't think calling someone a whore and a slut every voicemail is harassing?
I guess it could be considered.
Okay.
But if you deserve it, you need to be called that.
Okay. You get mad when she doesn't answer the phone when you call. Isn't that true? True?
Yeah.
Okay. You want to control her, and when she doesn't take your call, you get angry.
No.
And it's her of having sex with you said you just got out of a gang is what you said. What do you mean by that?
Gangbang.
Okay. So that's what you say. That's what you assume she's doing if she doesn't answer your call.
No.
Well, that's what you said.
Well, I might have said at that time.
Okay. On Exhibit 5 here, I want to know, what did you mean when you told her, "Hey, Skank, this is my new target for tomorrow morning"? What did you mean by that?
I had a piece of her china that she has now set out and took a picture after I found out who she was screwing.
And so you're threatening to destroy her china.
I was after I found out who gave her $40,000, yes.
Okay. So you were threatening to damage some of her property.
I did make that threat.
Okay.
But I never damaged anything.
You said earlier that there was an incident where she was pushed on a gate and you pushed her back. Remember that?
Yes.
Did you cause her arm to bleed?
She caused my arms to bleed.
Is this a picture of her arm bleeding after that incident? Judge, may I approach?
You may.
Is this a picture of your wife's arm bleeding the day of the incident?
Probably not. She probably went in there and made it look worse because I don't remember anything like that.
So when you said you haven't hit her, or you haven't harmed her, that wasn't actually correct, was it?
I didn't harm her. I just gave her back the gate she gave me.
I got a question for you. Why, you said earlier, your attorney asked you if you had stalked her, and you said that you admitted that you turned around and followed her. What were you going to do with her when you caught her?
I did catch her, but
Okay.
I turned around and left. I wanted to make sure who it was.
Well, you saw her when she passed. You were
No.
glaring at her.
She's got smoked glass in her vehicle. I was there looking at the traffic go by, and all of a sudden I looked up and somebody shot me a bird.
And you did a U-turn and went after her.
I didn't do a U-turn. I just pulled out behind her because I was going that way anyway. I didn't pull out behind her. I pulled out behind the line of traffic that was behind her, and I had to wait to get to the turning lane to pull over to see if it was her.
Commissioner, how many guns do you own?
10.
Where are those guns now?
They're in my gun safe.
Are all of them in your gun safe?
All except the ones I gave away to my family.
Just those are my questions.
Just no.
Mr. Mitchell, you didn't know that was your wife's vehicle because she had a new vehicle. Is that correct?
I knew that she had a new vehicle, and I knew it was the same color as the one that came by, but I did not know it was my wife.
You just didn't know if it was some random person that shot you a bird.
Right.
Because she had totaled her vehicle and had a new vehicle, and you didn't really know what it was. Is that correct? Or you had a general idea, but you didn't know if that was...
No, I knew it was her vehicle because we both have been to ball games together. She sits at the stands, I sit at the end of the dugout, so we stay away from each other. I do not approach her at the end of the ball games. And I mean, I have been as close to her as me to the judge at one of the ball games, just at the end of the ball game when we're saying goodbye to her grandson. but I've never approached her.
Were you injured at the incident with the gate at the house?
Yes, ma'am, I sure was.
Okay. Tell me about the injuries you received.
Bruises and blood.
Okay. And you have pictures of those, is that correct?
I think I gave you pictures and they're in the main files.
All right. But you have those, is that
Yes.
correct? Okay. And you understand from today and from our conversations that you cannot air a tag or anything, and you're not planning on doing that. And you only did it once. It was during your marriage. You had not separated. The divorce had not been filed, and you haven't done anything since then. Is that correct?
I haven't put an air tag on anything since then, since that was December of 24.
No, divorce wasn't filed till May of the following year. Is that correct?
Right.
That's all I have, Your Honor.
Anything further, Mr. Williams?
No,
Step down. Have a seat by your lawyer. You have any other proof, Ms. Snow?
No, Your Honor.
You wish to put on rebuttal proof?
No, Judge. Do you wish to have argument or?
I will hear you an argument.
All right. Judge, this behavior is escalating. It's getting worse, and we now know that Mr. Mitchell admits to tracking his wife back in December with an AirTag. He testified by his own testimony that he would not have taken it off if she hadn't confronted him about it. I don't know what the distinction is, whether they're still married or not, because it doesn't matter. The statute doesn't really matter if you are tracking your spouse or your girlfriend. I mean, it's illegal to track a third party without their consent. He has stalked her. He admitted now that he's taken pictures of her at someone else's house through the woods and then goes on that person's property to take a better picture. He admits that he's angry with her. He thinks she deserves this behavior that he is putting towards her, and he doesn't see a problem with it. He even said, if you act this way, then you deserve to get called these things. My client has a serious concern. It is harassing behavior. It is annoying, but it's also threatening. When you tell someone, "I hope you die," after calling them 9 times in less than an hour, and with everything they've been through, I think it amounts to that she needs an order of protection. And an order of protection is only good as a piece of paper, but hopefully he'll get the hint, stay away from it. Judge would also ask to be awarded attorney fees for this.
No.
Your Honor, there's a huge burden on an order of protection. The behavior that the victim alleges has to be where they're in imminent harm. Most of the
Does it
circumstances.
say that in the statute?
It says, well,
But not the statutes that I've been reading this morning. It only requires that abuse be inflicting or attempting to inflict physical injury on an adult or a minor by other than accidental means, placing an adult or minor in fear of or in physical harm or physical restraint, causing malicious damage to the personal property of the abused party, or intentionally engaging in behavior that amounts to financial abuse. It also goes on to identify that victims of domestic abuse also include people who have been stalked. So just wanted to make clear that I've been reading the statute during this hearing, so I'm pretty well familiar that it doesn't require the type of immediacy and seriousness as you were saying. But I've interrupted you, so please continue.
Well, Your Honor, I think it refers to the definitions in 3917-315 as it deals with stalking and harassment. And it says that it would cause a reasonable person to be frightened, intimidated, molested, terrorized. Your Honor, a lot of the behavior of Mr. Mitchell occurred before the divorce complaint was even filed. She never filed an order of protection then, filed one in November of 24. She didn't file one in November of 25. She didn't even file one immediately after the contact on June the 27th. She waited 2 or 3 weeks, and she did it right after mediation, and it wasn't successful. Your Honor, I don't feel like she feels threatened. I don't think that Mr. Mitchell's conduct goes to that extent. Has he been upset? Yes. Is he the first person that has called his spouse a name during the pendency of a divorce? No, he certainly isn't. As you know, this court's heard lots of testimony, and in divorce cases, and it's pretty common that people call each other names when they're getting a divorce. I don't think that in and of itself is enough to issue an order of protection. Your Honor, my biggest concern with this is that the parties will not be able to participate in family functions. He has no desire to be around his wife, but doesn't want to be limited in these type of functions. Your Honor, I would respectfully request that it be dismissed. This divorce has been pending for a long time and she's never done anything. So I feel like it's being done as a strategy to get back at Mr. Mitchell or to accomplish some end result to keep him from having contact with his the party's family. And I would respectfully request that it be dismissed, and I would request that I be awarded my attorney fees.
In this day and age, people oftentimes say things without relevance to whether or not they're true. But it's always been this court's belief that words matter. Words carry significance. That's why you can have an assault against someone even though there's no physical contact, because your words could place someone in fear of imminent injury and so forth, just simply in the context and under the words that are uttered. So I've been doing this a long time, probably longer than the two lawyers that are involved in this case. I've been judge now. This is my 12th year. I've represented a lot of people who are charged with abusing their spouse and so forth. I've heard a lot of cases, as Ms. Snow points out, and she's right. It's not the only case that we hear people calling names. But in all of my years, I can say that I don't think I've heard anything quite as vile and offensive as this list of phone messages that Mr. Mitchell inflicted upon Mrs. Mitchell. Sure, he may think she's having an affair, then that's fine. File for a divorce yourself, get a lawyer, take it to court. But calling someone these vile and offensive names repeatedly, calling her over and over and over again, and then at the end of that saying, I hope you die, coupled with the fact that she was aware that in the past you had placed a tracking device on her car. And by the way, 3913-606 of the Tennessee Code says electronic tracking of a motor vehicle except as provided in subsection B, which has to do with law enforcement. It is an offense for a person to knowingly install, conceal, or otherwise place on an electronic device, tracking device, in or on a motor vehicle without the consent of all the owners of the vehicle for the purposes of monitoring the following an occupant or the occupants of the vehicle. That's a Class A misdemeanor. Now, the statute's already run on that since it was apparently more than a year ago, but that's clearly a situation where you committed a crime against your wife. And then, and she knows that. She knows that you had done that. And then you have these other situations where you are following her, and clearly that's been within recent times. If you don't want to be married to someone that you think is running around on you, that's fine. We can deal with that. But that does not mean that you have, even if she's your wife, that you have the right to use the type of language and to place her in fear of that. And I think it is a reasonable fear that she has when the man that she's been married to for 53 years, who has tracked her, is following her, and then on June 27th sends her a series of text messages that accuses her of everything under the sun, some of the most offensive things that you can imagine. And then at the end of that says, I hope you die. I can understand why she would be in fear for her safety. I think a reasonable person would. So it is this court's opinion that stalking of her, as has been proven by your own testimony, and the most significant thing that you said today, the most significant thing I heard was when Mr. Williams was cross-examining you, and he said, if she hadn't confronted you, you would have continued to have tracked her and stalked her. And you said, yes, he would have. Well, that tells me that there is a need for a protective order to prevent this stalking from taking place. Now, I do find that there is a basis for finding that an order of protection should be extended. However, the order of protection does also contain certain abilities of the court to allow for certain contact between the people, sometimes called social contact. And for that reason, I do not intend for this order of protection to prevent Mr. Mitchell from having an opportunity to attend his grandson's birthday party. They will have no direct physical contact with each other. They will have no direct, they won't speak to each other. And they won't, and this goes to her too. I don't think she wants to speak to him, but he should be allowed to be there. This will be a social contact that allows him to be at family functions, so long as he does not have any direct physical contact with Mrs. Mitchell. Now, he told me you want to see your grandchildren, that that's what you want. I'm going to give you that right. I have grandchildren of my own. I don't want to ever be prevented from being able to see them. But if you violate this order, you're not going to get to see your grandchildren because you're going to be in jail. I don't want to do that. I don't want to put you there, and you don't want to be there. So make sure you understand. This may have been a temper tantrum that you threw that day, but as I've said, words matter. And in this case, I think the words that you used on the June 27th phone messages repeatedly are so severe that, coupled with the previous AirTag stalking and following that, this thing that occurred in November of 2025, all of which serves as a basis for this entry of this order. Mr. Williams will submit his application for attorney's fees, and I will consider that as a part of the record.
Judge, I just submitted order with a blank in there and my attorney fee affidavit.
That would be fine.
Thank you, Judge.
That concludes this hearing. I hope that the two of you, at some point, the two of you had some feelings for each other. I know you've been married since you were 17. Is that right? So you've been together a long time, and I know you had feelings for one another. Whatever, it's easy to have harsh feelings towards somebody when you feel like that they're throwing away your marriage. But you don't want to be married to somebody that you don't trust and that has, in your opinion, been messing around on you. She doesn't want to be married to you anymore. So you two need to solve your problems. Just get away from each other. And maybe you can, in the future, have some sort of a relationship where you can at least tolerate each other enough to be around your grandchildren at some public events. All right. There will be no messages of any kind interchange. He will not text her. Any communication that you need to have with her, go through your lawyer. That will mean no direct or indirect. You can't send her a message by one of the other family members as well. Anything else that I've not touched on? Yes, as far as I know. I think we had, did we ever get the inmate up that we were supposed to be doing? He had been released up front. Thank you. All right, well, let's take up what we have left. National Electrical Company versus Sean Christopher Gary. This gentleman, I'm wanting to go ahead and try to take care of it, but one of the things that I'm looking at is a Rule 60 motion that's been filed, and it alleges that there was you're asking to set aside a default judgment that was entered in March. Is that correct?
Yes, sir.
That was before Judge Turnbow.
Yes, Your Honor.
It's always been my practice since I've been on the bench that if there's a Rule 60 motion to set aside a judgment that some other judge has entered, that judge needs to be the one to hear it. Any reason why Judge Turnbow could not hear your motion for Rule 60 relief?
No, Your Honor. I represent Mr. Geary and all about elect, and there's no reason that we would oppose Judge Turnbow hearing it.
Well, Your Honor, I'm Greg Oakley for the plaintiff, Your Honor.
I'll concede that he is Greg Oakley, and I've known him for many years. We've had cases together in the past. I'm sorry, Your Honor, I couldn't help it.
And Your Honor, I don't have an objection to Judge Turnbull hearing the motion, although it's really a simple motion that I think that Your Honor could handle, that we could argue in 10 minutes. There's not a whole lot of factual dispute. And I mean, if the court is prepared to go forward with the other motions, the motion for charging order and the motion for contempt, then I would prefer that the court hear the Rule 60 motion today so that we can get it over with.
Well, if I'm not going to hear your motion for Rule 60, I'm not going to hear any of the others either. I think it would be more appropriate to have the other judge hear it. But
Your Honor, can I be heard on that for a second?
Yeah.
So an issue that we have with a further delay with respect to especially the motion for the charging order, is that the subject of the charging order motion, which by the way has not filed a response to the motion, nor did it file a response to the motion for contempt. It's our understanding that the judgment debtor, Mr. Geary, formed this new company called TNT Electrical that does the exact same thing that the defendant judgment creditor All About Electrical Company was doing. Namely, it does electrical contracting work for this company called Divisions Inc. or Divisions Maintenance Group. They do electrical work at Sam's Clubs and Walmart and Costco's, places like that all over the country. And our information is that TNT is doing significant business with DMG, for which they're going to be paid a substantial amount of money. I filed this motion for a charging order back in early June because we would like to get a charging order in place so that all that money doesn't flow through to TNT and then disappear. This defendant, Mr. Gary, somehow disposed of $1.4 million in a 6-month period, $500,000 in a 3-month period. And we're just afraid that if this money comes in, it's going to go away and we're not going to be able to attach to it. And there's really no, a response has been filed by the defendants to the charging order motion, but there's really no defense to it. There's a judgment in place, and Mr. Gary does not deny that he is the owner of the LLC called TNT or TNT Electrical LLC. And so just purely as a matter of law under the charging order statute, we're entitled to a charging order. Now, we've asked for some reporting and for the appointment of a receiver. We can wait on that until Judge Turnbull can hear it, but we would like a charging order to be entered today, or the court to grant one and have me submit an order, because otherwise this amount of money that we could use to pay down the judgment is going to go away. We won't be able to get it back.
Your Honor, we did file a response, and our response was talking about the extraordinary relief that is requested. And this is, if the Rule 6002 motion is granted, it will be moved. They have asked for interest on the judgment, and they can always do post-judgment discovery. They can do all kinds of things. A short delay for the original for Judge Turnbow, who heard it, is not going to be prejudicial to these folks. And therefore, I think it best that one judge, the judge who's heard all this, Judge Turnbow, to hear and decide. And I'd also say, Mr. Oakley, who is a friend of mine, allowed me to file this Rule 60 motion last week. He did file a response on Saturday. On this weekend, I was 200 plus miles away for my mother's 100th birthday. I didn't get a chance to look at it until late yesterday afternoon or evening, and I haven't had a chance to talk to my client. So I think that it would be best just to hold all this off until Judge Turnbow's next date, and no matter what, we will be there.
Your Honor, if I can just briefly speak. I don't know if the court has read the Rule 60 motion or had the opportunity to it, but there's no.
I haven't had the opportunity.
Okay.
Not only was he away from this area, I was in another county this last week and was not able to review the file at all. So I'm going to want to review this file before I want to read the motion for Rule 60 relief. I'll probably communicate with Judge Turnbow here in just a minute and see whether or not he has any objection to me hearing it. And if he does think, as I do, that it would be more appropriate for him, I will determine whether or not that can be done quickly. If it can't be done quickly, then I'll probably hear this Rule 60 motion.
So, we also would not mind, I think I can speak to Mr. Oakley, going to wherever Judge Turnbow is and having it heard there in order to get it extra.
Let me step off. I need to check to see, when is Judge Turnbow back here? He was here in March, so that's not going to be. So he's not here till October. But I know he will be in other counties, and like me, I think Judge Turnbow was willing to set some other matters. So let's see what I can find out, and I'll come back in just a few minutes. So.
All right. Court, stand a brief recess.
No, I'm fine. Okay. All right.
He'd stand you up. I'd help him. I was in the time when this theater been over. He couldn't strike one. That's why.
No.
The record, I got Mr. Oakley's response on Saturday while I was in Memphis celebrating my mother's 100th birthday, and I didn't get a chance to look at it until late yesterday afternoon or early evening, and I've been unable to contact my client about it. Having said that, I'm prepared to go forward. There is no doubt that a default judgment was entered. There is no doubt that my client did not respond in time. According to his affidavit, he didn't have the funds to do it. Now, there's a counter affidavit that was filed I haven't had a chance to talk to my client about. But, Your Honor, Rule 6002 exists for a reason. It's not just out there in the blue. And it allows for relief from the judgment. And we're relying upon 6002, 2, and 5. That's exceptional circumstances. My client has It's filed an affidavit saying he didn't have the funds. He talked to many lawyers. I believe he said he talked to about 20 law firms. He couldn't find a lawyer. This is a fairly complicated case. He found me, and I have filed this Rule 6002 motion. The motion for default is at almost $1.1 million right now. It's probably a little more than that with interest. And so this is not a trivial matter. He has filed a answer and counterclaim, and he's making allegations against the National Electric Company and its controlling person. So the question becomes, is this an exceptional circumstances? Is this an exceptional circumstance? We understand that Rule 6002 motions are not granted easily, but this is a case where a $1+ million judgment has been entered. And as this court well knows, defaults are not favored in Tennessee. They've never been favored in Tennessee. I've been doing it for 48 years, and I've had many a default turned over. The default was entered in March of this year. So we're talking about a break of a few months. We are prepared to expedite discovery and get this to a very quick hearing so that it can be decided on the merits, which a case of this magnitude should be. I saw Mr. Oakley's response late afternoon, or actually evening or night yesterday, and I've tried to contact my client, couldn't get a hold of him. But I would like to respond to it. One side will make allegations, the other side gets a chance to respond. If someone doesn't have the money and doesn't know how to refer to it and has made good efforts to try to find a lawyer, he says that over 20 law firms or lawyers he tried to contact in his affidavit. He couldn't find one who would take it. If you can't pay a lawyer on a complicated case, or a lot of cases, lawyers simply not going to show up. This would be a grave injustice to him. He also has some claims in tort and conversion against the plaintiff, and those are set out in the counterclaim as well, Your Honor. They're also mentioned as defenses, recoupment, and set-off. So the question here, Your Honor, is real simple. Should we allow this case to be heard on the merits and decided? And I assure you we will expedite it, and I would work with Mr. Oakley to expedite it and get it heard and as quickly as possible. He and I have worked in the past, and I think we have a good working relationship. But be that as it may, I'm asking the court to set it aside and to go from there. I didn't have a chance to respond to the Saturday filing because I was out of town at my mom's 100th birthday. It only happens once. So I appreciate it. Thank you very much.
Mr. Oakley?
Yes, Your Honor. Again, I'm Greg Oakley for the plaintiff, and I have here with me Mr. Ryan Carney, who's the president of the plaintiff. And just to address the whole Saturday filing, this motion was filed on Tuesday afternoon, which is really not even 5 days from today, which is the minimum time to file a motion. And I had depositions all day Wednesday and Thursday, so I did my best to put together a response on Friday. I had some technical issues that kept me from filing it on Friday afternoon, so I filed it on Saturday, but that was just 3 days after the motion was filed. And Mr. Kraft has glossed over what his motion actually stands for, or what the reason that his clients claim that they're entitled to Rule 60.02 relief. What they claim is that.
Let me just say this. I did read through the motions, and I had not read your response because I wasn't aware that you had filed it. But in my short recess, I did read through his motion and what he claims.
Right.
So go ahead.
Okay. And the motion was filed pursuant only to 60.02 for excusable neglect, not 60.05 or 60.025, excuse me. In any event, since Your Honor has read the motion, you understand that the claim is my client said some bad things about Mr. Gary, and therefore their biggest client stopped doing business with him, and he didn't have any money because of that. But someone who is requesting Rule 60 relief has to substantiate this request with clear and convincing evidence. Right? The evidence that has been submitted by the defendants is the affidavit of Mr. Gary, who says in the most vague possible way that sometime in the summer of 2025, my client said bad things about him to a third party, causing this third party to stop doing business with Mr. Gary. But this, nothing in the affidavit to demonstrate that Mr. Gary was present in this conversation, that it was recorded. How does Mr. Gary know what my client told some third party? It's clearly inadmissible evidence under Rule 602 because Mr. Gary lacked personal knowledge. It's also hearsay, Your Honor. I mean, the only way that Mr. Gary could possibly know what two other people said is if somebody else told him. That person would be a declarant, which makes it hearsay. So it's inadmissible under Rule 602. It's inadmissible under Rule 802. And it's completely uncorroborated and unreliable and, frankly, Your Honor, not worth anything. So just from the outset, the burden of establishing what they need to establish with clear and convincing evidence has not remotely been met, Your Honor. Furthermore, it's also not true. And this may be kind of hard to tell from my response because I had some issues with the exhibits, but I attached as exhibits to my response several months worth of bank statements of the defendant All About Electrical Inc. And so the reason this case exists is because my client, NEC, National Electrical Company, had an arrangement with AAE, All About Electrical, which is owned by Mr. Gary, under which NEC was providing the labor and materials for these electrical projects. AAE, Mr. Gary was in theory supposed to be supervising the projects, but my client was furnishing all the labor, all the materials. The contract was between the owner, DMG, and AAE, Mr. Gary's company. The deal was that Mr. Gary's company, when it got paid by DMG, was supposed to give that money to NEC, which it would then use to pay the expenses, the labor, and the materials. And then NEC and AAE would split the profits 50-50. Mr. Gary did that a little bit, but especially towards the end, he completely stopped doing that, kept all the money for himself. And I attached, like I said, exhibits as the bioelectrical bank statements as exhibits to the response. And they established that, so the complaint was filed and Mr. Gary was served on October 15, 2025. In the 3 months leading up to that filing and service of the complaint, All About Electrical Inc. deposited $700 and something thousand into its bank account. Almost all of that was payments from DMG. Now they did make a couple of payments to NEC, but there was more. I think it was $546,000 that was deposited in the accounts in the 3 months leading, actually the 4 months if you count October, leading up into and right after the filing of the complaint. And Mr. Gary claims in an uncorroborated, unverified, and unsupported affidavit that he didn't have the money to hire a lawyer because my client had said bad things about him sometime in the summer of 2025. He claims he didn't have the money in October of 2025 when the complaint was filed, but the bank statements show otherwise. I mean, I don't know what he did with this $546,000, but the allegation, unsupported and uncorroborated, that he didn't have money because of something that my client did is completely unfounded, Your Honor. So Mr. Gary had more than enough money to hire a lawyer in October of 2025. This is not a case, the usual cases for excusable neglect are miscalendared the date. Something happened that caused me to miss court. Something like that happened. That's not what we have here. What we have is a untrue and unsupported affidavit filed by the defendants. If Mr. Gary didn't have money to hire a lawyer, he could have contacted the court and said, I see it happen all the time. When motions for default judgment are heard, people stand up and say, Your Honor, I can't get a lawyer because I don't have money, or I'm trying to hire a lawyer and I can't get one. And a lot of times the court will say, okay, and they'll reschedule the motion. Mr. Gary did nothing. He chose not to respond to the motion for default or to defend the case in any way. And so Under those circumstances, we don't have the type of excusable neglect that supports a Rule 60 motion in the rare instances that Rule 60 motions were granted. Mr. Kraft has not cited, and I couldn't find, because I don't think there is one, any case that says that I didn't have money to hire a lawyer means that you should undo the default judgment that was entered against me months ago when I did nothing to try to delay the proceedings or anything like that. Because if I didn't have money to hire a lawyer was enough to get judgments undone, then there would be no final judgments in the state of Tennessee. Everybody could just come in months later and say, well, I didn't have money to hire a lawyer, so please undo the judgment. But there are no cases that support this because it's not supportable under Tennessee law. So even if Mr. Gary didn't have money, and frankly, even if he didn't have money because my client called him untrustworthy and incompetent, which he absolutely is, that is not the basis for a Rule 60 relief based on excusable neglect. Also, Your Honor, in order for a defendant to be entitled to Rule 60 relief, they have to demonstrate that they have a meritorious defense. There's been no demonstration of any defense in this case. All we have are the unsupported statements, basically the unsupported denials of Mr. Gary. But the bank statements that are attached as exhibits to my response show that our claims are valid and he doesn't have defense because he was receiving all of this money, which just went out to places we don't know. And my client did not receive anywhere near what they were supposed to receive. So his just denial saying I didn't do it does not demonstrate a meritorious defense when it's not supported by anything else. So again, even if his assertions are true, it does not give rise to Rule 60 relief. And finally, Your Honor, the last reason why the court should deny the motion is that a Rule 60 motion has to be filed within a reasonable time. This lawsuit was filed last October. The default judgment wasn't entered until March. Mr. Gary states in his affidavit that he, in March, he started doing business again because he persuaded this company that what my client had supposedly said was wrong, but he still waited 5 months to file his motion, Your Honor. And under those circumstances, the plaintiff submits that that is not a reasonable time. So for all those reasons, the plaintiff respectfully requests the court to deny the motion unless the court has any questions. That's all I have.
Right. Thank you. Your Honor, as the leading case is Sizemore, a Tennessee Supreme Court case, lays out 4 factors. The danger of prejudice to the party opposing. Very hard to see any prejudice when there's interest that they've accrued. The fact to the answer and affidavit he has submitted, he has sworn to the facts that they are true. He has submitted an affidavit in connection with the Rule 6002 motion. The time is 1 year, except for 5, but this is within 4 months of the default judgment, not a judgment on the merits. Excusable neglect is an equitable doctrine, and the potential impact very small. He explained why it was late, and he had control. Now, this response was filed on Saturday, and as I told the court, I didn't have a chance to look at it until late yesterday, and I hadn't been able to get a hold of my client. But I think I need time to respond. He's filing in good faith. He has asserted meritorious defenses and a counterclaim, which are sworn to. And when you file an answer or a complaint, it's a verified counterclaim. It is sworn to, Your Honor. There's an affidavit that's attached to it. Now, the affidavit talks about what happened, and it's sufficient for Rule 62. This is not a proceeding in the trial where we put on proof of witnesses. There are affidavits in the record, affidavits which support my client. And trying a lawsuit is not considered prejudicial to a plaintiff. That's the Urey case, which is a Supreme Court decision of last year, Tennessee Supreme Court. The fact of the matter is my client is asserting that he's owed money. My client's asserting that he's owed commissions on other sales and that his own was taken by them. So, Your Honor, this is not, and that he's saying that a lot of what the plaintiff is contending is simply not true. Equitable, what this means, excusable neglect, If someone has unclean hands, and we assert they do, we have affidavits to that effect, and we're ready to go with this case. We're ready to file an answer and a counterclaim today. Attached to were the motion for the order for default and the proposed answer and counterclaim. So I urge this court to grant the Rule 6002 motion, or at least give me a chance to respond to Mr. Oakley's filing on Saturday. And I said when I spoke, I filed it on Tuesday. I'm not claiming he was dilatory whatsoever, but I'm claiming he's made some serious allegations I'd like a chance to respond to. Thank you.
Well, considering the fact that the motion itself was filed less than the 5 days notice given to Mr. Oakley, and his response obviously was under pressure to get it done before this hearing today, I am inclined to grant the defendant an opportunity to respond to, because there are some pretty serious allegations that Mr. Oakley makes, and that is that Mr. Gary's affidavit is false and contains false and easily provable false allegations, and bank records which tend to indicate that the defendant or that the plaintiff is correct. And I've made a cursory review of them, and it does appear that if in fact Mr. Gary had $500,000 come through his business in a period of time, that he certainly could have afforded to hire an attorney. But beyond that, I don't know that, as Mr. Oakley states, that it's a basis for a Rule 60 excusable neglect, that in fact he didn't hire a lawyer because he claimed he didn't have the money. That's not necessarily in our jurisdiction a basis for that. So what I'm inclined to do is to withhold a reserve ruling on the Rule 60 motion, and I'm going to go ahead and enter an order that, because of the fact that it's being reserved and we're still going to argue it, to order that the charging order be put down so that any funds that you need to protect yourself with could put a charging order down that would follow this judgment, would follow those funds until we can have that Rule 60 motion. That is the best I can determine is the fairest way to give both sides an opportunity to present fully. But I do think that it's a higher burden than simply saying it's not fair, that he didn't have the opportunity to hire an attorney, and that, look at his affidavit, he says that they're wrong and he's right. That seems to me not to be sufficient, but I'm going to give you an opportunity to respond, and I think we need to have a hearing on it. The question is how quickly we can get that heard. Are either of you opposed to traveling outside of this county to have a hearing?
I'm not, Your Honor. I just need to check my calendar. As far as the charging order is concerned, all money would have to remain in place and couldn't be spent without court approval. Would that be correct?
All money what?
All money in the charging order?
We can put in the charging order that the money will be paid into court.
Correct.
Or into an escrow. It doesn't.
Or escrow. We'll work that out.
But as long as it's
Two of you can agree on something that would be satisfactory to me. So,
okay.
How much time do you need to respond? Because I want to give Mr. Oakley an opportunity to review what you filed as well.
Your Honor, if I can get to my calendar, I'm not real fast at this. I apologize. 73, and I don't do this. If I could have a couple of weeks, Your Honor, that would be grand. I think unless that's the 4th of July weekend, I don't have pressure on either of us. Whatever you want.
We're way past the 4th of July.
You're right. I'm sorry.
That was August.
Sorry, I look in July. Old age.
How long? Well, you were going to have 30 minutes this go around, but
Yeah. How about 3 weeks? In 3 weeks, that puts us right after Labor Day. Is that okay?
right after Labor Day. That's more than 3
for,
weeks.
Yeah, for me, 3 weeks, and then Mr. Oakley, 3 weeks. That sound reasonable?
I don't need 3 weeks, Your Honor. I mean, I need a week. So I think a month from today, whatever's closest to that, in the area of approximately a month from today.
Well, here's how my schedule works. I'm going to be starting the rest of this month. I have Chancery tomorrow. I'm sorry, I have VOP day here tomorrow. Then I have Dixon Chancery on the 29th. I have Humphreys County Chancery in Charlotte. My 2 lawyers who agreed to move theirs to Dixon County. On the 30th, I have Dixon criminal motions on the 31st. Then I start Stewart County on the 3rd of August.
You know where you're going to be in October, Your Honor?
Do what?
County will be in October. I mean, in September rather. Excuse me.
September, I'm in Dixon County.
How about that?
I'm sorry, Your Honor. I don't know if I understood from what you said. If there's something available sooner than September for Your Honor.
Well, that's what I'm looking at. So, all right. What about the 17th of August?
It works for me, Your Honor.
1 second, Your Honor. If I can get to it, I'd appreciate it. 17th of August. I have a telephone hearing in the morning. That should be done by 10:30 if we can do it in the afternoon.
Well, I'm supposed to have a circuit civil docket call in Chancery in Houston County, but those dockets are usually very light. So I'm looking at probably 1:30 in Charlotte, Tennessee. I need to step off and call the clerk to find out if that's doable. So give me a minute.
All right. They're registered. Yeah. You have to go up to Clark's. I saw.
It's the guardian ad litem. Is it okay if I take a table?
All right, this is a motion. What I'm considering today is a motion regarding the enrollment of the children, minor children in Cheatham County schools. That request that's been made.
Yes, Your Honor, that was my motion. That was,
You want to wait till your client can come
if
in?
we could. And Your Honor, I also, thank you. I also filed an answer or a counter motion. Thank you.
I don't know why that microphone doesn't seem to be working.
I filed a counter motion this morning. I've emailed it to both of the attorneys, and I set one up there with Miss Pam. I am asking that instead of allowing father's motion to enroll the children in Cheatham County, that the children be allowed to come up to Indiana and enroll in Eastern DeKalb County in Indiana.
Okay, I'll hear both sides. The first motion that was filed is that of the father who is asking to enroll the children here in Cheatham County. So we'll take that up first, and then I'll let you present whatever you want on your motion.
Thank you, Your Honor.
If you'll just have a seat. We're waiting on Mr. Brown to come into the meeting.
I can call him too if that might speed it up. It's saying incorrect password.
On this, what I gave you surprised me today. If it's a phone call, it may be somewhat different. Do you have the information? Can you give it? There's a different password, I think. If he's coming in on Zoom on a computer, you should be able to. Is your client still trying to join?
I told him to also try the phone option if the video is not working, the call in. And I double checked the number on the sticky is the same one on the email printout. Is it still not letting you? All right, hang up and I'll just keep trying.
I have admitted apparently you're a client, so if he wants to be a participant, he can turn on his camera if he's coming in on the phone.
I am, in Your Honor.
Right. Then we are ready to proceed on your motion.
Yes. Your Honor, this is my client's motion. This was originally filed early in June. I believe it was sent in on June 5th, in fact, before any hearings were ever set on this case. My client wasn't served with a petition when the mother left the children with him and went to Indiana. For all he knew, she was leaving the children with him. She had no understanding what her plan was to file a petition. Then it took a while to get him served. He's been concerned about getting the children enrolled in school. Last year, they were in kindergarten in 5th grade in Clarksville. Neither party lives in Clarksville, even though this court has already denied mother's emergency request to relocate the children to Indiana. The mother's still residing in Indiana. The children need to be enrolled in school somewhere. My client's position is that allowing the mother to have the final decision if they're unable to make an joint educational decision that the current parenting plan allows for will put him in a position of the mother going ahead and enrolling the children in school in Indiana. He also has concerns about the elementary school in Indiana, which is rated pretty low as in comparison to the Kingston Springs Elementary School, which it looks like it is a 10 out of 10 from his research. To keep this case moving forward, but we're kind of up against the clock on getting the kids enrolled in school pretty quickly. He's willing to get the kids to and from school and make reasonable accommodations for the mother to be involved to the extent she can, even though she already had moved to Indiana. As far as opening, that's all I have. If you want to let Mr. Brown, did you need him to turn his camera on? I do notice that that's not on.
Mr. Brown, you'll need to turn your camera on, please.
I don't know if it'll allow because I'm on the phone call side of it. I don't see any option for it. Just my normal keypad for a phone call. Since the
All right.
Zoom app won't allow me to log in.
Then let me hear from Ms. Celine. Well, Ms. Squires, you want to make an opening statement. I understand your position. You pretty much have given me your opening statement a moment ago. Do you have anything else to add? I'm going to give you a chance to testify if you want to testify.
I would like to testify.
Ms. Salinas?
Your Honor, I have been on this case about 2 weeks. I do have some concerns. I've been able to speak with the mother, I've been able to speak with the father, and I've spoken very briefly to the children via Zoom. The children attended school in Clarksville, and it looks like they maybe attended, the oldest child may have attended there a little over a year. And then I think she had attended in West Cheatham at some point in time. I don't believe she's ever attended school and I will tell you, I have 2 girls who both went to Kingston Springs, and it is a good school. But a concern to me is I met with Father in my office just a few days after I was appointed, and I had asked him some questions, and I had asked him to send me some photographs of his home, just so I could have a better idea of where the children would be living. And as of today, I had not received, well, as of today, I've not received photographs from him. So I drove out there yesterday, and I have some real concerns about the environment that the children would be staying in if they were to reside full time with the father. He was very honest and forthright with me in my office. He had told me that he had, and I don't remember how we came on the subject. I guess I was maybe asking about where the kids would be able to, to play and type of thing. And he was very forthright and said he had only cut the grass a couple of times this summer. And I'd mentioned that, wow, we've had a lot of rain. It's been hot. Maybe that was something that needed to be done. And clearly, when I arrived yesterday, the grass is terrible. I don't know that there's any cutting it. I think it'd have to be bush hogged. There were several vehicles. It's just the house was not a conducive environment, at least outside, for these girls to play in, to bring friends over. And so that concerns me. I also asked the father if he smoked, and he said he did. And I asked him if he smoked inside, and he said he did. And so we talked about that. That concerns me. I also find the dad's lack of involvement with school concerning. So I have some concerns, and I'm not certain that the children being enrolled in Kingston Springs would necessarily be in their best interest. So what's the other alternative? They can't go to school in Montgomery County. Mom's not living there. And wherever they go to school, it might be temporary, whether it's in Indiana or in Cheatham County. But my position would be that Indiana, even if it's on a temporary basis, if that's what it ended up being, might be the better option. Mom has provided me with the information I requested. She provided it promptly. And I would submit that it's likely, at least in my opinion, a better environment for these children.
All right. Ms. Knight, do you want to put on any proof other than argument?
I do want Mr. to testify.
All right, Mr. Brown, if you can hear me, I'm going to ask you to let me place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right.
Mr. Brown, you heard some statements that the guardian ad litem mentioned to you about some concerns.
Yes.
Are you currently out of the state?
Yes, I am.
And how long have you been out of the state?
Since the day that I met with the guardian ad litem.
So have you been at home and able to take any photographs of your home?
No, I have not.
Okay. Now, there was some concerns mentioned about the condition of the grass. Is your grass pretty high right now?
Yes, it is. It's about 3 foot high, probably.
Okay. Can you tell me why your grass is that high?
Every time I mow, I get about partially cut through, and my mower deck belt breaks, and it's about $100 to $150 belt. I'm going to be replacing that mower.
So are the children able to play outside in the grass in the condition it is at your home currently?
Part of the front yard, but you'd have to walk a little bit through the front grass if you didn't go out the front door.
Okay. As an alternative to playing in your yard, where do you allow the children to play?
We go down to Burns Park quite a bit, splash pad and fly kites and playground at Burns. Also, other friends' house down there in downtown Kingston Springs. Go to their house and they play with the two other girl friends of some friends of mine on their trampoline in their backyard and all.
Is that something you do on a regular occurrence?
Quite regularly, especially the park and the splash pad and Dixon and all that.
As far as your previous involvement in the children's education, how far away from your house were the kids in school last year?
60 miles from my place.
How long did it take you to drive from your house to their school?
Just over an hour each way.
If the kids had an appointment during the middle of the school day in Clarksville, would you be able to attend those during the middle of the school day last year?
Not really. With an hour there, an hour back, I can't just sit around Clarksville all day. I try to work in appointments.
That you were not able to participate, or that you were not able to participate because of your employment?
Employment and cost, because it's basically $50 a day running them back and forth to school to Clarksville.
Have you done any research into where the children would be enrolled in school if they were enrolled based on your residence? And where would that be?
The school where the mother's at, the elementary school actually covers up to 6th grade, so both girls would be in that elementary school and not the junior high school. And their school ranking is a 4 out of 10. They're very low on the Indiana State. They're about, I think, 487 out of 500, just over 500 schools.
And have you done any research on the schools where the children would attend if they were living with you?
Yes, Kingston Springs Elementary and Harpeth Middle School.
And are those schools similarly rated to the school mother would be zoned for in Indiana?
The middle school, Harpeth Middle School, is currently this last year, they actually ranked a little lower than their normal average. I believe they were a 6 out of 10, but Kingston Springs Elementary is a 10 out of 10. One of the top schools in Tennessee for elementary on the public side.
Did you do any educational exercises with your children during the school year last year when they were with you?
Just a little bit with Clara, not with Allison. She does great. She didn't even never had homework anyway. There was never any homework.
Okay. And during the school year, you were seeing them, was that Thursday night through Sunday night every other week? So your parenting time during the school year was somewhat limited, correct?
That's correct.
Okay. And now tell me about picking the children up on Thursdays and on Fridays during your alternating weeks. Did you pick them up early from school?
On Fridays, a lot of the time I'd pick them up a half an hour early because they just have recess at the end of the day. And I'd pick them up there. They stop for early cutoff at 3:15, and I tried to get in there right between 3 and 3:15, and they released at 3:45.
Were you still taking the children to do physical activities since they were missing recess?
Yep. And that helped us avoid all the traffic of getting out, rush hour traffic and all sorts. So it doesn't take more than the hour and 5 minutes to get back.
If the children are going to school in Cheatham County this year, would you be able to get them to and from school every day?
Yep. And there's also a school bus already in the neighborhood. There's multiple kids up and down the street. Girl next door, boy 3 houses down.
Are they similar ages to your children? Would you be able to assist the children with any homework or educational needs during the school year if they were enrolled in Cheatham County? Would you be able to, if the children were enrolled in school in Indiana this year, would that impact your ability to be involved in their day-to-day educational or extracurricular lives?
Absolutely.
And how far away is that again?
About 7-hour drive.
And do you think that's an issue that the court should decide at an ultimate final hearing rather than at this juncture of the case?
Yes.
That is all of my questions for this witness.
Ms. Squires, you are representing yourself. You have the right to come to the podium and ask questions. I know you've been through this before representing yourself, but make sure that your questions are in question form.
Thank you, Your Honor. All right, Mr. Brown, I'd like to start first with your home. Is there any damage to your roof?
There is some hail damage on the roof.
And when did that occur?
The first hail damage occurred back in 2020.
Has your house ever been hit by a tornado?
The house was not directly hit by a tornado.
Have you received any roof damage because of a tornado?
Yeah, that's the hail damage and some wind damage from December of 2020.
Has that caused any leaking into your home?
I have leaking in my bedroom.
Anywhere else?
The living room has one little spot on the exterior wall that I've removed the drywall on.
Is that the area by the light switch with the plywood?
Yeah.
Okay.
There's a light switch there.
Is there a way that I
There's no,
can,
there's no plywood.
is there a way that I can show him this photo to see if he recognizes it? I know over camera it
I
may
don't
be
know if he's
difficult.
able, are you able to see this
Oh,
proceeding, or are you simply watching or talking on
No,
the phone?
no, sir. I'm directly on the phone.
So he can't see it? I don't think there's any way we can demonstrate it to him, so.
okay. We might be able to do this. On the opposite corner of the door where you have the plywood, on the other side where you had the love seat, up in that corner, is there any mold, or has there been
There's
any mold in that area?
there had been. That was the major spot where I had to go up and patch the roof to get the leak to stop.
Okay. And when did you perform those repairs?
I repaired the roof, and that was 2021, I believe, when I had to go up and put more shingles up there.
And with that molding, did you ever have an inspection done to verify that there's nothing dangerous growing in the home?
No, never been sick.
And going again with your home, you said that there's a limited area that the girls can play in outside. Have the girls ever gotten into a tick nest?
Yeah, in the neighbor's yard.
Oh, it was in the neighbor's yard?
They got into a seed tick, baby tick nest, playing on the rope swing at the neighbor's yard.
So that wasn't along the property line?
No, ma'am.
Okay. All right. I'd like to go on to, have you ever left the children alone together?
I have Elshon at the house. The only time I'd briefly leave them alone would be to run around and get Gatorades and cigarettes at the market, be gone for 5 minutes.
So you do leave the home, and do you tell Allison that she's in charge of Clara? Or how do
I
you,
said, lock Claire up, but you can get a hold of L because he's in his room if they need anything.
and Elle is always there. You've never left the children home alone.
He's pretty much always there. I never leave him home alone for any long period of time.
So yes, you do leave the children home. You just don't leave them home for very long periods of time. Brief periods, but yes, you do leave them alone. And then, have the girls ever had any issues with that? Any kind of arguments, fighting back and forth?
Not that I'm aware of.
Okay. And you leave, you say Elle is in the back room to watch them. So,
Yep. And to notify him that I'm leaving.
so he's not out in the rest of the household. He just stays back in his room most of the time.
He'll crack his doors.
And how's his health?
Fine.
Has he been out of the home for any length of time because of hospitalizations?
Yep. In the past.
And what medical condition does he have?
If I should be testifying on somebody else's medical conditions.
I'll move on. With let's go ahead and go into education, and I guess some of their medical information is going to overlap into this as well. You're aware that I enrolled Clara Brown into Mark Their Words?
If she's cross-examining my client at this point, I didn't ask anything about any medical issues for the children. And if the court wants to clarify that she's free to go ahead and testify at this point and call him as her own witness, just it's going beyond cross-examination at this point.
How is it going beyond cross-examination? She's asking him if he's aware of her having enrolled the children in something.
In therapy.
She's asking about therapies and medical issues. That's not something that was brought up at all on his direct.
The Judge Cross is wide open.
There is no limitation on, unless we're limiting the proof on a specific issue. But in this case, the therapy or care for the children, medical care or therapy for the children is in fact a factor that the court would have to consider if I am making an informed decision regarding the best interests of the children, enrolling them here in Cheatham or there in Indiana. So overrule the objection. Mr. Brown, if you will restate your question, Mr. Squires.
Thank you. Mr. Brown, are you aware I had the Clara Brown enrolled in Mark Their Words therapy for speech therapy services?
Yes.
And what is your understanding of that treatment that Clara Brown was receiving from that facility? Pronunciation, are you aware of any diagnosis that they have given her?
That she needed, the paperwork that I've seen is that she was needing to work on different pronunciations of different letters.
Okay. Does phonological disorder ring a bell?
Not off the top of my head.
So you're aware that she's receiving treatment for speech, but you're not aware of the specific condition that she has been diagnosed with. Is that correct?
That's correct.
Okay. Do you recall ever receiving any communication from me trying to encourage you to participate in that therapy?
I know you were trying to schedule because they wanted it 3 times a week,
Hmm.
and you were trying to schedule it on Fridays also.
And when I wanted to schedule those on the Fridays in which you would be exercising your parenting time, what was your response to me?
I know you asked about taking her, and had no objection to you picking her up and taking her, because you did offer that.
Did you ever clarify to me that you were okay? So, let's make sure that this is clear. I believe you were referring to during one of my attempts to get you to participate in this treatment, I offered to come out to Kingston Springs and pick Clara up and drive her if that's what needed to happen in
You
order
are
to
now
get her.
testifying, and you cannot testify. You can only ask questions at this point.
All right, I apologize. Did you feel that there was a need for your daughter to have these services?
Yes, because she was enrolled late into pre-K and kindergarten.
Do you think it was helpful for her to be withheld and receive these services first before she started school?
She didn't receive them first. She should have been in pre-K at least 2 years ago.
All right, so do our children receive any other therapy services?
Allison goes for anxiety. That's all I've been told.
That's all you've been told? Is Clara also receiving therapy services for an ADHD diagnosis?
I haven't seen any actual confirmation of ADHD diagnosis.
Have you scheduled an appointment for Clara with the psychiatrist that treats her for ADHD?
I have never talked to a counselor or supposed psychiatrist that's seeing her.
You've never spoken with Molly Fields?
That's the one that does it. She speaks to both of the girls.
So you scheduled
And she's
therapy services for your daughter,
never
but
given me diagnosis.
I apologize. Could you repeat that?
She's never given me a diagnosis.
Have you
of
ever asked
ADHD.
for it?
No,
Because you have a right to your children's medical
understanding.
files. Have you ever asked for it?
One at a time, please. Let her finish your question, but let him answer the question you've asked.
Yes, sir.
You were having what they call a compound question. Restate your question. And I would point out to you again, I have one issue before me today. This is not a hearing on your permanent relocation request. This is a hearing on where the children should be enrolled for school until there can be a hearing on the request to relocate.
Yes, sir.
So limit your proof to those issues, to that one issue.
Did you schedule an appointment with Molly Fields for Clara Brown?
I scheduled Zoom calls over spring break and Christmas break for both girls with Molly.
When do the girls usually receive their appointments with Molly?
I thought it was during school.
So outside of the school time is when we schedule appointments by Zoom with her? Is that your understanding?
During the breaks, I set up Zoom calls with her because she reached out to me requesting them.
Okay. All right. Do you recall ever receiving any letters that Molly Fields has typed up in regards to the girls' diagnosis and treatments?
I've never received anything directly from Molly.
Hold on, Mr. Brown.
My client's already stated it's not received
Mr.
any
Brown, wait just a
documentation.
second. Sustained, again, I want to focus the relevance of all your questions on the schooling and the education rather than medical care.
Okay, I apologize, Your Honor. The reason why I was pursuing this line of questioning is because by answering this, am I testifying? I'll stop.
You can give me your reason why you feel like it's relevant, but it's not going to change what I just said.
Yes, sir.
What I want to hear is why you think the children should be enrolled in school in Indiana versus here. And any questions regarding the education that is offered, that Mr. Brown can offer, is fair game. But
Yes.
the questions about therapy, I've allowed some of that because it is a part of the care for the children as well. But if you can ask him any questions you want to about his proposal regarding the educational needs of the children, then that's what I'll need to hear.
Okay, I'd like to move on to the attendance records of the children then.
All right.
Ms. Knight, have you got a copy of that?
No. You provided it to me?
I wasn't sure if this was something that I had provided or not.
I've not received anything from you.
This is a temporary hearing and the discovery is not being completed. We haven't been to mediation. That's why this is a temporary hearing. So if you have a question for Mr. Brown about the attendance records for the children, go ahead.
Sure. Mr. Brown, what time does Barksdale Elementary end their school day?
3:45.
3:45. And how many days would you say that you pick them up early?
Most of the school year, I picked them up early.
Around 3 o'clock. And you say this is in order to avoid traffic?
Part of it, yep.
Do you think any other parents in the school have to deal with traffic?
I doubt any of the other parents drive an hour.
Well, that's not what I asked, Mr. Brown. Do you think any other parents have to deal with traffic?
I'm going to object
Well, yeah.
on behalf of the court. I'm going to object to that question as being requiring Mr. Brown to speculate about what other parents have to do or not to do. You have made the point about the fact that he picked them up 45 minutes before the end of school, which this court finds to be unacceptable.
Okay, thank you, Your Honor.
Any other questions?
No, Your Honor, I believe that will.
Ms. Salinas, do you want to ask Mr. Brown some questions?
A few, Your Honor. Mr. Brown, you met with me for the first time on July 17th. Is that right?
Yes, ma'am.
And that, do you remember what day that was? I believe it was a Friday. Is that right?
Yes, ma'am. It was Friday. You got
Okay.
on hold of me on Wednesday, the 15th. Yes.
You very promptly replied, and I appreciate that. Now, when did you go to Indiana? So that was the 17th.
Friday. I got in late Friday night.
So
The
did you go
17th.
the same day that you had met with me?
Yes, ma'am.
All right. But when we met, you had disclosed to me that your yard had only been cut a couple of times during the summer and that it was pretty long on the 17th. Is that right?
Yep.
So
That is
it's
correct.
not, okay. It's not that it grew between the 17th and today, which is 10 days. Is that right?
No, that is correct.
Okay. All right. And we had talked about, at least I had relayed that it might be important to get that grass cut. Is that true?
Yes, ma'am.
Now I have in my hand 3 pictures of your home. What is the address of your home?
1018 Dogwood Lane.
All right. And unfortunately, you're on your phone and I can't show you these pictures, but I'm going to ask to move them as an exhibit.
I mean, I've never personally seen the house. I'm not saying I don't take your word. I don't have any issue stipulating that the grass is very tall.
Well, Judge, I'd like for you to see how tall the grass is, and I can't help it. He's on my
Ms.
phone.
Salinas is entitled to introduce whatever proof she wishes. Mr. Brown is not here, but his lawyer is, so she can review the pictures.
I have no objection, Your Honor, either. I know how it looks.
And there were several vehicles in the grass, and one on the drive, and one under. Looks like maybe one has a cover on it. Is that right?
Yeah, my roommate has a few vehicles there that he's stolen 2 of them.
Okay. And you said that the grass has not been maintained because you need a $150 belt. Is that right?
I can't even get one complete mow out of a replacement belt, so I'm just going to be replacing the mower.
Well, but you told me you were on track to have a record year from a financial standpoint with your business. Is that right?
On sales, record year of sales, if everything works out, if all the jobs finish, because it's a new construction project. So.
And certainly in the Kingston Springs and Pegram and White Bluff area, there are several lawn services that could come cut your grass. Is that right?
That is correct.
And I mean, your children, they're young. They're 11 and 6, right? They like to play outside, don't they?
Yeah, they usually go over to the neighbors down the street.
Well, do you think they'd ever like to have friends from school come to their home and play?
Oh, yes.
And it would be pretty difficult to do that in the condition your home is in currently, wouldn't it?
That is correct.
And you've been involved in this case for how long? How's this
Years.
case been back before recently? How long has this case been back before the court?
On this matter,
Yes, sir.
let's see, since June.
So 2 months essentially, and you're kind of under the microscope right now, asking for the girls to come live with you primarily and be enrolled in school. And that, I mean, yard certainly wouldn't show it, would it? That you're willing to do what's needed to get this home in a fit condition for the children to.
I'm just waiting on my cash flow on accounts receivable, and then I'll have a mower.
Well, but you had the money to drive to Indiana and be in Indiana for the last 10 days. Is that right?
Actually, a friend gave me the money to do it because I'm in charge of build and tear down every year.
Tear down of what?
The music festival stage, charity stage.
Okay. You have a roommate. How old's your roommate?
He is 62,
How long has he lived with you?
about 4 years, maybe 5 years now.
Do the girls
5 years
have their
probably.
own? Okay, and I don't mean to talk over you. Do the girls have their own room at your home?
Yes, they have their own room,
They okay. How many bedrooms does this house have?
3 bedroom, 2 bath.
Okay, so do the girls share a room?
Yes, they have bunk beds,
And how many baths?
2 bathrooms.
Let's just put
Move on.
a stop to it right here. Have a seat. This hearing today is designed for one purpose only, and that's for me to make a determination on a temporary basis whether the children should be enrolled in school in Indiana, where the mother is located, or has relocated, or here in Cheatham County. And the proof has been that they've never been, or at least have not recently been enrolled in Cheatham County. The problem the court has, and the hesitation that I've had, is that Miss Squires has moved out of the state and relocated to Indiana without having followed the procedures set forth for a parental relocation. She instead filed an ex parte petition for relocation. And this court is very familiar with this case. I've heard multiple in this matter. I've done my best to try to put an order down that would allow both parties to be a part of these children's lives. There have been a lot of allegations in the past that these two, but nonetheless, Ms. Squires has been, under the prior orders of this court, designated as the primary residential parent for these children. She has had the children for a period of I believe it's 200 under the last order. She has the children for 222 days, 52 days a year, and he has 113 days per year. So the only question is, until we have an actual hearing on the relocation and whether or not she should be allowed to relocate or should be ordered to either return to the state of Tennessee with the children or give up custody of the children, which is what the final hearing will be about. The court has to make a determination where the best interests of the children lie, whether being left here with Mr. Brown and enrolled in a school they've never attended, or to Indiana in a school that they've never attended, and with the mother's situation. Based on the testimony that has been offered at this point, I am finding that the motion to enroll the children in Indiana with the mother should be granted, and that the children should be enrolled in school there pending a final hearing on the petition for relocation. This order that I'm entering should be granted by the guardian ad litem, in my opinion. Since Ms. Squires is pro se, I want to make sure it reflects everything the court is ruling. And this order is not to be determined by either party and shall not carry any significance regarding the final determination of whether or not a parental relocation and a relocation of the children to the state of Indiana is in their best interest. This is purely a decision that I make for the moment to allow. In other words, Ms. Squires had been worried about Mr. Brown wanting to have the children enrolled here so that he could have a snapshot of what it would be like for him to be there. The same thing could be said of Mr. Brown, worried about your having the children enrolled up there, and therefore you've got a record. I'm going to allow you to enroll them in Indiana, but the enrollment of those children in Indiana will not be a factor that the court will consider at the final hearing, so that both of you will have an equal opportunity to, once again, try to give the court an opportunity to make the decision that's in the best interest of the children. And hopefully by the next time we have a hearing, I'll be able to talk. All right, Mrs. Salinas will draw the order.
Your Honor, concerned as to what implications that might have on the current parenting plan.
Current parenting
once
plan
school
is in
begins.
force.
From my client's parenting time is Thursday to Sunday night. That would be impossible living 8 hours away.
He's in Indiana right now.
He is coming back today.
Said, but I mean,
What school
he knows how to
begins?
get to Indiana. He went up there for a week-long music conference, apparently. So all I'm saying is that this decision that I'm making today was based on one thing only, and that is the question of whether the children should be enrolled. I have not altered the parenting plan. These parties need to come up with an opportunity through Ms. Salinas, if nothing else. Maybe they can use her as a medium to try to come up with a best interest for the minor children. He's entitled to have his visitation, and it just depends on how long. I'm going to order that they go to mediation as well, because I think that, well, mediation with Ms. Squires as a pro se would probably be counterproductive, I would think. So in any event, he will have visitation on weekends, and if he cannot make it work where he has the entire weekend, he will exercise as much of that, and that will not be held against him at the final hearing. Mr. Brown's situation in his home is a large part of the reason why this court has made it. I look at those pictures. I've had to mow my grass every week, even though I don't really want to. As soon as I get finished mowing it, I'm having, probably part of the reason I sound like this. As soon as I finish mowing it, I have to start all over again. And all I'm saying is that he's got minor children who need to be able to be outside in the home. Those photographs that I've shown show almost waist high grass, and that's unacceptable for minor children of this age. We got an 11-year-old and a 7-year-old. Leaving them alone for him to run out and get some cigarettes and Gatorade, that's highly questionable. Even though he's got a roommate in the back, it's not his roommate's 60-some-odd-year-old gentleman. Is not, in this court's opinion, it's not his responsibility to provide for the care of the children. So he has a house that's leaking, it's had mold in it. All of those things are factored into this court's decision. And the guardian ad litem's report about her concerns is also a great part of this. So while it is inconvenient that this has happened, Mr. Brown may have a remedy available to him at the final hearing for Ms. Squires as having unilaterally left the state of Tennessee without prior court approval. So we'll deal with that. So, all right, Ms. Salinas, you draw the order.
I will, Your Honor.
And that concludes our business for today. We stand adjourned.